Welcome back, welcome back, welcome back. Welcome back, welcome back. Woo! It's getting hot in here, so don't take none of your clothes. I'm getting so hot, I want to take my clothes off. Don't nobody follow those instructions because that is not what I'm intending. I just wanted to sing that song. It's getting hot in here, so take off all your clothes. I am getting so hot, I want to take my clothes off. Mm-hmm. 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 What is this guy doing? Let's get into this courtroom. Let's see what we got going on here. Where is the judge? Where's the judge? Where's the judge? What's going on? Uh-oh, whoa, 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 whoa. Did they? Oh, big and blue. Uh-oh, here we go. It look like they don't have a lot of clothes down there. Because he looked like he wearing the same attire from yesterday. Boop, 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 boop. Flex. Time to have. That's what I think of when I see Maddie Flex name. That's not good, Maddie. You remember that song? Flex. Time to have. Woo. And we used to be like butterfly with our head like flex. Time to have. Yeah, he done came back like, oh, he's so handsome. What's up, Hellcat? I know Maddie gonna have to change his name. That's all I can think of with that song when I see him. That's why I be like, oh, he's so handsome. He didn't change his picture so he want a super chat to go up here so y'all can see his picture. So y'all can all be running around here talking about, oh, he's so handsome. Oh, sweet. So they must don't have many clothes up in here. Because he looked like he in the same blue from yesterday. I'm just saying.
touch base at the next break. Does that sound good?
Certainly not.
Okay, thank you, Sergeant Brown. Okay, all right, let's bring in our jury.
Your Honor, should we have Detective Smith on stand before the jury comes up, or do you want?
Yeah, let's have them on.
Thank you.
So, and I'll say that again when the jury comes in, so they can hear it.
Yes, ma'am.
Sure, yeah. I wasn't told anything else, so you guys are getting lucky over here. Good morning, ladies and gentlemen. Welcome back. Please be seated. And Detective Smith, you are still under oath, sir. Prosecution, you had no further direct?
I did not.
All right, then we're cross-examining Mr. Hernandez.
Good morning.
Morning.
Just so the jury is clear and remembers from yesterday, you were present in the room during the interview of my client, Mr. Hernandez, correct?
Yes, ma'am.
Okay. And it was your understanding that he had requested to talk to police, and that's why you went down there, among other reasons, obviously, to pick up the items that had been seized. But one of the reasons you went down there is because he had requested to speak to you, correct?
Yes.
Okay. Obviously, people that are under arrest do not have to make a statement, fair to say?
Yes.
Okay. And obviously you went through and we were able to watch you going through his Miranda rights, correct?
Yes, ma'am.
Okay. And in that Miranda statement, it says that anything he says could be used against him, fair to say?
Yes, ma'am.
And he wanted to still talk to you after understanding those rights, correct?
Correct.
Now, in one part of the video, I think actually in a few parts of the video, there was a statement that was made either by yourself or the other detective that was there that Yogi, or Mr. The co-defendant in this case, was scared of my client. Do you remember that?
I do.
Okay. And do you remember actually a statement was made, he was scared what you and your people can do to him and his family, correct?
Yes, I do remember that.
Okay. That was a lie, correct?
I don't know.
Okay. The co-defendant here was never, Mr. Zuazo was never interviewed, correct?
I don't know. I didn't have anything to do with Mr. Zuazo.
When you interview someone that you believe is a suspect, especially in a crime that involves violence, it's important to look at the person you're interviewing to see if there's any fresh wounds, correct?
Yeah.
None were noted, correct?
Correct.
Would you agree with me that that conversation was pretty jovial until the question was posed of Mr. Hernandez, why not the wife? If you killed the husband, why did you leave the wife alive? Do you remember that line of questioning?
I do, yes, ma'am.
Okay. And do you recall at that point in time, that is when my client's demeanor changed, and he repeatedly said it was not supposed to happen. Do you remember that?
I do, yes, ma'am.
I have nothing further.
And redirect?
Yes, and Detective, you were under the impression during your investigation that the homicide in Rochester occurred on October 11th.
Yes.
And what day was it again that this interview was conducted down in Louisiana?
October 17th.
All right, so roughly a little over 6 days later.
That is correct.
No further questions.
You want any follow-up on that? No. Okay, all right, thank you, Detective. You may step down.
And may this witness be excused?
No.
Judge, before we call the next witness, I think we need to have a break because Mr. McCarthy's not here yet.
Okay, all right, ladies and gentlemen, so I'm gonna send you back out to for a break. The break is going to require you to say your jury. Okay, all right, I'll get you back as soon as I can. All right. Does it just make sense to have Mr. Zuazo brought up instead of? I don't think Mr. McCarthy's. Where's Mr. McCarthy?
I'm sure Mr. McCarthy is very prompt. I'm sure he'll be here in the next 60 seconds. He knows to be here at 9. I agree to have Mr. Zuazo brought up. Makes the most sense. I can check the hallway for Mr. McCarthy. Well, I can call Mr. McCarthy.
What do you think? Greg, do you think it's okay to keep Mr. Hernandez here for right now? You good with that? Oh, all right. So why don't you just have a seat, Mr. Hernandez? We're gonna try to get up Mr. Zuazo.
No, I didn't, Merelda. Thank you so much for putting that in. Thank you, Smatty. Oh, he just wanted this picture to be up here. I got it. I got it. Thank you. Thank you. Thank you. Who received the gifted membership? Let's see. I don't know. Let's see. I have to look somewhere else to see it. Terry Lynn received the gifted membership. Awesome, awesome, awesome. I think she was over here a couple days ago. I think I seen her. Awesome, awesome, awesome. Appreciate it, Maddie. Thank you so much. Yeah, I was kind of in another screen. I'm trying to what am I doing? I'm trying to make sure I got the Twitter feed up just in case something come through. I can keep an eye on it for us, even though we in court over here. So that's what I was doing. Oh, okay. Now his shirt got to be stinking now. Is this the same shirt, Jason? That courtroom probably feel all types of ways. I wonder what the jury thinks when they wearing the same clothes like this. It's almost like a TV show. Oh, this day number 3 in the same shirt. Y'all think they washing their clothes every night? There's probably all types of funk going up in that courtroom. So, so, so funkified. I don't know why we can't have different shirts. And our boy, he over here in deep sea blue. know. We got one on day 2 of close. At least he did try to switch it up the one day. And then we got this other guy that didn't have this on the last 3 days.
Is there any restrictions regarding the images being streamed or?
Unfortunately, the juries are gonna have to see this.
Okay.
Good approach to be sworn in by the court.
Good morning, Dr. Frank.
Good morning.
Stay standing, raise your right hand, I'll get you sworn in. Do you swear affirm the testimony you're gonna provide is the truth, the whole truth, nothing but the truth, so help you God?
Yes, it is.
All right, please be seated and then tell us your name.
My name is Shauna Bryan.
Your witness.
Good morning, doctor.
Good morning.
Can you tell us how you're currently employed
I am the Deputy Chief Medical Examiner for Oakland County
and how long have you been a medical examiner?
for 6 years.
And do you have a medical degree?
Yes, I do.
And you have enhanced medical training after your basic medical degree? And I don't mean basic as basic because it's not, but after graduating medical school, you also had more training.
Yes.
And have you had specialized training as a pathologist?
Yes, I have.
And have you testified in criminal cases before?
Yes, I have.
A part of your duties as a medical examiner to document what you've seen in reports.
Yes, it is.
Is part of your duties as a medical examiner to photograph the injuries that you see so that they can be documented through photographs.
Yes.
And as a medical examiner, are you to determine a manner of death?
Yes, I am.
And can you tell the jury when you determine a manner of death, what does that mean?
The manner of death means how the death came to be about.
And define that. What does that mean?
Well, there's only 5 manners. So one would be homicide at the hands of another person, suicide, your own hand, natural, and you form a natural disease like cancer, for example, heart disease. And then there's accident, which is unintentional, like a car accident, and then undetermined when we can't assign or we don't know.
Okay. And do you also determine a cause of death?
Yes.
And tell us what a cause of death is.
The cause of death is the initial injury or disease that leads to death.
Okay. And there's all different types of causes of death.
Yes.
Okay. You could have drowning as a cause of death.
Yes.
You could have a stab wound.
Yes.
You could have a gunshot.
Yes, of course.
And those things you document in your autopsy report.
I do.
Do you have an autopsy report that corresponds to this case?
Yes, I do.
I'm going to show you what's been marked as People's Exhibit number 4. It's an autopsy report for Hussein Murray, case number 246922, with the date of death of October 11th, 2024, and the date of your autopsy is October 12th, 2024. Do you recognize that?
Yes, I do.
And that has your signature at the end,
Yes.
and there's attached diagram at the end of that,
Yes,
and also a toxicology report.
that's correct.
And those are all done in the ordinary course of your duties.
Yes, they are.
And when you do a toxicology, what is the toxicology report?
Toxicology, we usually take fluid from the eye, blood, and then sometimes urine, sometimes gastric, but usually we'll send blood out for toxicology studies, which will test for any alcohols, drugs of abuse, certain prescription medications, things like that.
And that's a standard thing you do as part of autopsies.
Yes, it is.
Your Honor, if it wasn't in the record, I'd move People's Exhibit number 4 into evidence.
All right, it's in.
And I have no objection to its admission.
Doctor, I want to direct you specifically back to your autopsy on October 12th of 2024. Do you recall conducting the autopsy on Mr. Murray?
Yes, I do.
Okay, I'm going to show you what's been marked as People's Exhibit number 4A. It's going to show up on your screen close by. These exhibits we've already agreed to enter, so I'm not going to ask you all the questions that otherwise I would. You understand?
Yes, I do.
I forgot something. Have you been qualified as an expert before the courts of the state of Michigan?
Yes, I have.
And how many times have you testified as an expert before?
Around 15.
Okay. And had you actually testified as an expert in this case itself in district court?
Yes, I have.
Your Honor, the people would move Dr. Bryan as an expert in forensic pathology.
Your Honor,
Yes, any objections?
I had no objection in the preliminary examination. I also have received her curriculum vitae, and I have no objection for the trial purposes to qualify the doctor as an expert.
Okay, Ms. Lawson?
No objection, Your Honor. Thank
All
you.
right, the witness will be deemed as an expert in the field of forensic pathology.
Okay, looking at exhibit number 4A, is that a standard placard that you would give any autopsy that you're going forward with, so that whatever is logged in as far as photographs could then be referenced to that number?
That is correct. So the top number is the case number that was assigned, and the bottom number is the date that I did the autopsy.
And when you get a body in to begin an autopsy, do they usually come in if they're closed from a scene where they're already dead versus unclothed?
They can come in either way. It depends if they're on the scene and they have clothes, they will come in with clothes. If they make it to the hospital and the hospital does any measures, usually they do not have clothes.
Okay, and in Mr. Murray's case, did he come in dressed or
Yes, he did.
undressed?
Yes,
Dressed.
dressed.
Okay, I'm going to show you what's been marked as Exhibit 4B. Do you recognize Mr. Murray?
Yes, this is how I saw him when I entered the room.
And when he entered the room, you'll notice that his hands are bagged.
His hands have bags, yes.
Okay, and are there any bindings that you notice on Mr. Murray's body?
Underneath the bags, yes.
Okay, and what did you notice underneath the bags?
Underneath the bags, his hands are bound by duct tape and a couple of zip ties, as well as you can see the binding around the mouth and the head, and his feet were also bound by duct tape.
I'll show you what's been marked as People's Exhibit number 4C. You recognize that photograph as a different angle of the bindings around his hand?
Yes,
And that also depicts the black duct tape that you had discussed and zip ties around that wrist.
yes,
Were those eventually removed?
yes, we did remove them.
Were those bindings tight to the body of Mr. Murray, or did they just come off easily?
They were tight.
I'll show you what's been marked as People's Exhibit number 4D. Do you recognize that as another angle of those bindings?
Yes, I do.
And do you notice the condition of those bindings in regards to the Rolex watch?
Yes, where the watch is in between the bindings are tight on there.
I'm going to show you what's been marked as Exhibit 4E. Do you recognize that as a side photograph of Mr. Murray's right side?
Yes, it is his right side.
Okay. And that there's a gun holster on his right side?
That is correct.
Okay. And it came in without a gun, is that correct?
That is correct.
I'm going to show you what's been marked as Exhibit 4F. Do you recognize that as a photograph of the lower legs of Mr. Murray?
Yes, I do.
And were they also bagged as were his hands by the sheriff's office?
That is correct. Yes.
And is that common procedure when you receive bodies in?
Yes.
I'll show you what's been marked as 4G. Do you recognize that as a photograph of Mr. Murray's lower ankles after the bag is removed?
Yes, I do.
And can you tell us what you see in that photograph?
There was duct tape around the feet.
Okay. And there's a shoe on one foot?
One shoe on one foot.
And which foot is missing the shoe for the record?
The left foot.
I'm going to show you what's been marked as 4H. Do you recognize that photograph?
Yes, I do.
And can you tell us what you see in that photograph?
In this photograph, we've taken the clothes off and we've cleaned him off so I can properly see the injuries to his face and body.
Okay. And what observations do you have of any injuries that may catch your attention of Mr. Murray's face?
In this photograph, you can see that there's purple blotching around the eyes, which is bruising. On the face, he has a bunch of bruising all the way from the forehead, all the way down to the front of the neck to basically the collarbones. And he has some lacerations, which are tears in the skin and around the jaw. That's what he has. And then the jaw is also fractured. You can't really see it though in this picture.
Okay. I'll get into your internal investigation as we go forward. But for 4I, People's Exhibit 4I, can you tell us what you see in Exhibit 4I?
Yes, this is his lower lip as we've pulled down to take a photograph because there's some tears kind of on the left side of the lip and bruising on the inside.
I'm going to show you what's been marked as 4J. Do you recognize that as Mr. Murray's right hand?
Yes,
And can you tell us what you see in that photograph?
it's just his hand.
There's no cuts to his hand.
There are no cuts, no injuries.
I'm going to show you what's been marked as 4K. Is that another angle with the fingertips of Mr. Murray's right hand?
Yes, it is.
And again, do you see any injuries or cuts to his right hand?
No.
I'll show you what's been marked as 4L. Do you recognize that as Mr. Murray's left hand?
Yes, I do.
Okay. Again, do you notice any type of injury, bruising, or cuts to his right hand?
No.
I'll show you what's been marked as 4M. This is again a different angle with the fingertips of Mr. Murray's left hand. Do you see any type of cuts or bruising to his left hand?
No injuries.
I'm going to show you what's been marked 4N as in Nancy. Do you recognize that photograph?
Yes, I do.
And can you tell us what, if anything, is of interest when you're looking at photograph 4N?
Yes, so this is the back of him. We rolled him over to take pictures of the back. You can see on the scalp, kind of up toward the top of the picture, there is a laceration or a tear in his scalp there.
And can you tell us what type of force does it take, or what type of object does it take to create that type of injury?
Lacerations, bruises, and abrasions like a tearing, superficial tearing of the skin, are all caused by blunt force trauma. Anything blunt can cause these injuries, or like from a fall, as long as it's not like a knife, let's say.
I'm going to show you what's been marked as 4O. Is that a close-up of what was in 4N?
Yes, it is.
And can you tell us what we're seeing in 4O?
So it's a close-up, as you said, of the scalp, kind of like the left right here, and he has the tear in the scalp right there.
Was there a second injury to his scalp?
Scalp, yes.
I'm going to show you what's been marked as 4P. Is that depicting the second injury to his scalp?
Yes, so this is a close-up. It's on the back of his scalp about here, another tear.
Okay. And is that something that can be caused by blunt force trauma?
Yes, it is caused by that.
And any type of blunt object can be able to cause something like that with enough force. Is that correct?
Yes, that's correct.
When you started your physical observations of Mr. Murray, was he consistent with an individual to be 72 years old?
Yes.
Did you determine his weight?
Yes, I did.
And what was Mr. Murray's weight at the time of his passing?
295 pounds.
And how tall was he?
He was 72 inches or 6 feet tall.
Now, you noticed the zip ties around his hand and wrist. Is that correct?
Yes.
You photographed that, and you photographed the evidence of his injury, correct?
Yes.
Now, you started to discuss something about the internal injuries that you later noticed to Mr. Murray's jaw. Can you tell us what, if anything, you noticed regarding the internal injuries to Mr. Murray's jaw?
Yes. So inside, it actually could even see it in one of the pictures where the lip was down. His jaw, this bone here, was fractured.
Okay.
And then there was a lot of bleeding and bruising just on the skin and underneath the skin.
I hear the terminology. Over time, I get used to it, but a lot of folks aren't used to it. So we've talked about lacerations, we talked about bruising, but what do you mean when you say fracture?
Fracture's broken bone.
Okay. And there's different types of fractures?
There are different types, yes.
Okay. How would you describe this type of fracture?
I would say comminuted, meaning broken into multiple pieces.
And does it take substantial force to create that type of injury?
Yes.
Did you notice injury to the left side of his scalp?
Yes, I did.
Okay. And how did you designate and describe that injury?
He had a laceration or a tear there on the left side. Once we open the head and reflect the skin back, he has hemorrhage underneath the scalp.
And when you say, go ahead.
Oh, and there are two muscles here that help you chew. He had hemorrhage in those muscles.
Okay. We're going to slowly go through the definitions, but when you say hemorrhage, what does that mean?
Sorry, bleeding into the tissue.
Okay. And does it take substantial force to get bleeding underneath the scalp so that you could see it in the way that you did?
Yes, and it's a blunt force.
Did you notice any type of injury to his face?
Yes,
What injuries did you notice to his face?
his face has bruising, some tears in there.
Okay. Is it in one location or is it in multiple locations?
It's multiple locations, basically the whole entire face
Had bruises to
has bruises and tears.
it. When you started to continue your autopsy, did you notice anything that stuck out about his throat area?
Yes, I did.
Could you tell us what you noticed regarding Mr. Murray's throat area?
On his throat, it looked the same as the face. It has from the anterior neck here, which is the front of the neck, it had diffuse bruising and some kind of linear, no patterned, nothing like a pattern that I noticed, just some linear bruises.
Okay. And what did you notice when you got to look at his throat area internally?
Internally, we lift up the skin. He had soft tissue, which is bleeding into the fat and then the muscles in the neck that control the head. All of that was had blood soaked, and then he had a fracture of a bone in the throat called the hyoid bone.
Okay.
2 fractures.
Again,
broken hyoid bone.
the location of that bone, because we're not going to know by definition and description. Can you point to your actual throat to show us where that would be on a person?
Sure. The hyoid bone is a U-shaped bone, and it sits high up in the neck. If you feel when you swallow, your Adam's apple, that's called the thyroid cartilage. It sits just in front of that. That's high up in the neck and relatively well protected.
And what did you notice about that bone?
It was broken in 2 places.
Okay. In your experience in doing autopsies and going through school, is that a rare injury that you've seen?
It's rare.
Okay. And does that take a lot of force to accomplish that type of injury?
It does.
Can you tell us what type of other evidence of injuries you saw to the neck?
The fracture of the bone and just bleeding into the tissues.
Okay. And did you make any determination of how that could occur? How would that type of injury occur?
Neck compression.
Okay. Now, neck compression literally means compressing of the neck. Is that
Yes.
part of the definition I'm okay
That's
on?
literally, yes.
Okay. Now, hypothetically, would somebody with a lot of force using their hands be able to create that type of neck compression?
Yes.
Would an individual using a knee on the throat be able to create that type of neck compression?
Yes.
Would an individual using a shoe or boot on the throat be able to do that type of neck compression?
Yes.
How long would it take for continued compression of the neck to result in death?
So the answer to that question is a little complex. If somebody is unable to defend themselves, let's say they're unconscious or they can't move for some reason and pressure is applied to the neck, it's only going to take a matter of minutes, 5 minutes, less than 10 minutes, opposed to somebody who's able to fight back. It might take a little longer. How long, I don't know.
And were you able to determine if Mr. Murray was still alive when this was going on?
Yes.
And how were you able to determine that?
So the cause of death I've listed here is neck compression, but there's also a mechanism of death. Just because you break a hyoid bone doesn't mean you die from that. What he actually died from was asphyxia. This is the mechanism of death. Asphyxia, in the lightest terms, you compress the neck and the jugular veins and carotid arteries, which bring blood to the head and from the head, are compressed. This is where the asphyxia occurs. It takes only about 11 pounds of pressure to do that, which is basically the weight of your head. The reason I know it's neck compression is because the hyoid bone is fractured.
Okay. Did you determine a cause of death?
Yes,
And can you tell us what the cause of death was in Mr. Murray's passing?
neck compression. And I contributed blunt force head and neck trauma too.
And did you determine a manner of death?
Yes,
And what was your determination of manner of death?
homicide.
Okay. The injuries that you observed and the multiple injuries, Was there anything about those injuries that indicated it could only have been caused by a single individual acting alone?
No,
Was there anything about the multitude of injuries that you observed that excluded multiple participants in the causing of that death?
no,
Was there any type, talk about those neck compressions that we talked about. If I was, let's say, a 130-pound male, and I was trying to cause that neck compression, could a 130-pound male cause those neck compressions?
yes.
I don't have any other questions, Judge.
Okay, thank you. Cross-exam Zuazo.
Your Honor, may we approach?
Come on up. For a break. The break is going to require you to stay in your jury room. We'll bring you back as soon as we can. All right. Please be seated. And so now we're cross-exam Zuazo.
Thank you very much. Dr. Bryant, my name is Michael McCarthy. I know I met you back on the 17th of December when you gave your preliminary examination testimony in this case. I have questions to ask you. I'll tell you the same thing I told you that day. I have some questions to ask you this morning regarding your testimony. And if I don't make myself clear, please tell me that and I'll rephrase the question. Okay? All right. Thank you. Now, the manner of death is neck compression. That's the main thing that led to the death of Mr. Murray, correct?
Yes, the cause of death.
The cause of death. And while he sustained some tears in his scalp that are documented through the photographs that we've just looked at, those by themselves would not be the cause of death, correct?
No, the tears in the scalp would not be a cause of death.
It was the asphyxiation that actually caused his death, correct?
Yes, asphyxiation by neck compression and by the blunt force trauma sustained to the head and neck. Why? Because when you have blunt force trauma and he's breaking his jaw and it's bleeding into his nose and mouth, he's inhaling while he's still conscious, inhaling blood. If you're inhaling anything but air, you can't breathe. So that's part of the asphyxiation and why that's contributing.
And the way that you were able to make that determination is by examining Mr. Murray's lungs, correct?
That's correct.
And you found inside those lungs something that should not have been there, as well as all these other injuries, but blood in his lungs.
That's correct, under the microscope.
And that is the thing that led to the asphyxiation that ultimately caused his death.
Yes, that's correct.
Now, this hyoid bone, you've given a description of where it is, just at the top of your neck before you get up into your jaw area. Is that right?
Yes, that's right.
And you also talked about a fractured jaw. Those are two separate injuries, correct?
This is correct.
And now we have a jaw that, well, it's on both sides of our face, obviously. Was Mr. Murray's jaw fracture on one side or the other, or was it in the middle?
It was on one side, I believe the right side, and I don't recall the other. It was multiple places, not in the middle though, but on the sides.
Okay, so the jaw fracture is separate from the hyoid bone fracture, which was multiple, correct?
This is
hyoid,
correct.
and
Yes.
the jawbone was also multiple, correct?
Yes.
You said it took substantial force to create that injury, and also sustained compression in order to fracture the hyoid bone, correct?
Yes.
Now, because the jaw and the hyoid bone are in close proximity on the body to one another, would the same actions lead to both of those injuries, those fractures to the jaw as well as the fractures to the hyoid bone?
So the jaw is more from a blunt force trauma, any kind of hitting with an object or kicking or punching. The hyoid bone being fractured is the neck compression, more specifically.
Can you tell, after you conducted the autopsy or while you're conducting the autopsy, which of those injuries was sustained first?
No,
You can just look at the body, or all you're able to do is look at the body and note the injuries, correct?
this is correct.
All right. But you also said that as to the compression, the neck compression, it was over a sustained period of time, correct?
This is correct.
Now, on direct examination, Mr. Petrofessa asked you a question regarding whether a person of 130 pounds would be able to put that kind of pressure, that sustained pressure on the neck and cause the fracture of the hyoid bone. Remember that question?
Yes, I do.
And you said that's a possibility,
Yes.
correct? And that's all dependent upon somebody being unable to defend themselves, correct?
Unable or not, somebody could do that. It just would take a longer time if somebody was able to defend themselves and, you know, push somebody off of their neck, because really you're compressing the blood vessels there and you're asphyxiating.
Yes. And
So that's why the time has to be sustained for the brain to just go anoxic, meaning oxygen is not being delivered, and for you to die.
So a person who's got their hands bound is going to have a hard time, and their feet have a hard time fighting that off, correct? That
Yes, they
sustained compression.
Yes.
Now, would a person, I asked you this question at the preliminary examination, and I formed the question in such a way, I asked if a person in excess of 300 pounds would be capable of providing the amount of sustained pressure, the compression that led to the fracture of the hyoid bone, the two fractures that Mr. Murray sustained.
Yes.
Now, having more information, I'm going to ask you a similar but somewhat different question. Would a person, a man weighing 450 pounds, be capable of exerting the type of sustained pressure that is caused by that led to the death of Mr. Murray because of the fracture to his hyoid bone?
What you're saying, if somebody that weight can sustain
That
the
weight.
injury? Yes.
And 450 pounds is a substantial amount of weight, correct?
Yes.
And a person of that size could put that amount of pressure, or the required amount of pressure, to fracture the hyoid bone, correct?
Yes, this is correct.
Now, I know you said that a person that's 130 pounds could do the same thing, correct?
Yes.
All right, but you don't have any evidence about a person being 130 pounds doing that, correct?
No, I would not know who did it, what they
Sure.
look like, or what they weighed.
And when a person sustains that type of injury, I know you said there was internal bleeding, but I noted from the autopsy photographs that Mr. Murray, unfortunately and tragically, had quite a bit of external bleeding around the head, correct?
Yes, he did.
And that blood flowing, coming from his body when he was alive, correct?
Yes.
Rather than being dead, correct?
Yes.
Because when, and I know you understand this, and I just want to make certain that the jury understands it, when a person dies and their heart stops beating, then blood does not emanate freely or flow from the body, correct?
Yes, this is correct.
It's
Maybe
more-
maybe it will, but just a little bit, not as much as he had.
Because what it is then, when a person is deceased and their heart has stopped, it's gravity that leads to the blood coming out of the body, more so than the pump.
Not gravity, it actually is the pump. If the heart is no longer pumping, then blood's just going to cease to flow and it'll stop where it is.
That's what I'm saying. It's going to stop. But
Yes.
the fact of the matter is, you know, from your study of Mr. Murray, your examination of Mr. Murray's body, that this went on for as long as 10 minutes while he was alive, and the cause of his death, the blood in his lungs, accumulated while that tremendous compression was being placed on his neck, correct?
Yes, correct. Although I
And-
don't know how much time it
Okay.
took.
So would you agree that if a person is immobilized, as it's evident Mr. Murray was at the time of his death, and this person is, the pressure is being exerted by a person weighing 450 pounds, it might not take the entire 10 minutes, correct? On
It might.
highway bone?
It might not if he's completely unable to fight back.
The timing, well, you said it looks in, you don't have any evidence based on what it was that you were able to observe of the body with the bagged feet and the bagged hands, how Mr. Murray's body was delivered to your autopsy room, that he did any fighting back, correct?
I would not know that, no.
Right. And it doesn't look evident that he did, given those circumstances, right?
If he were tied up and then sustained injuries, he probably would have a harder time fighting back, yes.
And one of the things that you documented in the photographs that we looked at was his hands, both his right and his left hand, correct?
That's correct.
And you didn't note any injuries to those.
No injuries.
Okay. So that means nobody's in a fist fight, or he wasn't in a fist fight.
Correct.
I mean, it doesn't look that way
doesn't
in
appear
terms
that.
of what you're able to observe during the autopsy, correct?
That's correct.
So then this 10 minutes that you talked about, is that, I mean, obviously you weren't there, so you don't know as an eyewitness, but 10 minutes is an approximation. It could have been a shorter period of time.
It could have been shorter, it could have been longer.
Okay. Is there, I know you measured or I don't know that, tell the jury, did you measure the amount of blood that was in each of Mr. Murray's lungs?
No, I did not. And the reason is I can't quantify it. It's kind of like you get like a soaked rag of blood and you're trying to squeeze and measure. So it's not something that I can quantify.
Okay.
I just know it's there
You know that it's
because I can
there.
see it.
And would you consider what you were able to see and know for a fact was indeed blood in each lung? Was it a minimal amount? Was it a medium amount? Was it a substantial amount? What measurement would you use just because of the way based on your experience as an expert, you were able to observe?
It was a moderate amount, and this is the reason it contributes, moderate to severe. If it was minimal, I probably wouldn't contribute it, but it's more than that.
And because it's more than that, that is the reason why your cause of death, or what you have said is Mr. Murray's cause of death, but your conclusion is this neck compression leading to asphyxiation.
Yes,
And the asphyxiation is caused by the blood in the lungs.
the asphyxiation is caused by the compression of the vessels in the neck, one, and number two, the blood in the lung.
Two causes.
Yes, it's a contributor. The blood in the lung is a contributing cause.
Okay, the real cause
And then
is
the
that
main cause is
sustained
the neck.
pressure on the neck.
This is correct.
And whether it's 10 minutes, 5 minutes, 12 minutes, that's the cause of death, no matter how long it took, correct?
This is correct.
And the bigger the force, the faster it would have gone.
Likely it could have. Yes.
A 450-pound person could accomplish that end a lot more quickly than a hypothetical 130-pound person, correct?
Maybe if they were able.
Okay, thank you. I have nothing further.
Will you do redirect?
Yes, Jim.
Okay, go ahead.
Just a few questions on that. You didn't go to the scene, correct?
I did not.
Okay, and if the scene had shown a lot of blood at the scene, you would agree from what you just testified, that means that the heart is still pumping to put that amount of blood out there. Is that correct?
Yes, this is correct.
The blood isn't flowing at the scene until his heart stops. Would you agree with that?
It is not flowing, or
It wouldn't continue to flow
this is
until he
correct.
passes,
That's
correct? Okay. Now, there was some testimony earlier that you said he was conscious during this period because you have the blood inside his lungs, right?
Right.
And Mr. McCarthy asked about him being immobile, I think at some point in his cross-examination. Immobile has a lot of different terms and it can be vague for definition. Would you agree with that?
Yes.
Okay. If I'm bound with my hands and zip tied, that doesn't mean I'm immobile at that point, does it?
No.
Okay. I can still struggle with my hands like this.
Sure.
Okay. I can still fight back with my hands like this.
Yes.
Okay. The pressure on the neck, is that pressure on the neck from a frontal pressure? Could it be from a side pressure? Could it be from a rear pressure?
It's not from the rear because the bone is in the front, so it could be in the front or the side.
Okay. So if a person is conscious and they're struggling, there would have to be some other way to keep that head from flailing while that pressure is being placed on the throat. Would you agree with that?
Yes.
And there's nothing that you've testified to that couldn't be caused by a 200-pound man. Is that correct?
That's correct.
And the amount of time and pressure on that throat, if you start that pressure and you're choking and you're struggling and you're fighting, but you break loose of it for 10 seconds, for 30 seconds as you're struggling for your life, could that reset the clock of how long it's going to take?
Well, yes.
Okay. If a person is conscious and they're just not lying there letting you do this, that time period could change depending on how much of a fight is going on.
Yes, that's right.
I don't have any other questions.
Did you want to follow up?
Just on the fight going on, Doctor, you don't have any evidence about a fight going on. You can't see that from what you observed in the autopsy, correct?
Correct. I just know injuries on Mr. Murray.
Thank you. I have nothing for you.
Any follow up on
No,
that?
Judge.
Okay. Come on up.
Give you a break, so you're gonna go back to your jury room. The break is gonna require that you stay in your jury room.
All right, for the jury, please. All right, we'll take that moment for discussion. Everybody please be seated.
You spent a good amount of time on the cardiovascular system, is that correct?
Yes,
Okay. And you noted that he had 3 bypass grafts.
Please be seated.
Good morning.
Exam.
Thank you. All right, so I want to go over a couple of things that I noted in your report. So under evidence of injuries, which is on page 3 of the report, you have a section that you labeled blunt force injuries. Is that correct?
yes, it is.
Okay. And blunt force, as we talked about a little bit previously, but I'd like to make sure the jury understands, blunt force means that the person that you're examining was hit with something, correct?
Something blunt, yes.
Okay. Which could be a fist, could be an object, correct?
This is correct.
All right. And blunt force trauma, would you agree with me? It's not as definite as, let's say, a gunshot, where you're able to determine that a bullet hit someone because there's an entrance and an exit wound. Blunt force, you can't really say what the force was. You just know that it was blunt, correct?
This is correct.
Now, unless there is evidence of like a bite wound or a ligature mark or an imprint of a boot, again, you're not able to determine exactly what the cause of the injury was, correct?
That's correct.
Blunt force can even be when someone falls and hits the floor, correct?
Yes, of course.
So it is possible that some of the injuries that Mr. Murray sustained were caused by him falling, correct?
It's possible, yes.
Now, I believe you testified that none of the injuries to the head, the lacerations that we saw, are immediately life-ending, correct?
Not by themselves
Correct.
immediately.
All right, so let's now move to the neck. You listed obviously neck compression as the primary cause of death, correct?
Yes,
Now, a fractured or broken hyoid bone does not mean, in itself, does not mean immediate death, correct?
this is correct.
Now, you previously testified that to fracture or to break this bone, it would have been direct pressure specifically to the neck, correct?
Yes,
Again, that could be an object being pressed to the neck, correct?
yes, it could be.
Could be hands, could be a knee. You're not able to tell us.
That's right.
Now, is it fair to say that it's not actually the amount of force, it's actually the location of force that's most important for any type of injury to that area?
To the neck, you mean?
Yes.
Not the amount, but sorry, say that again.
So it's not necessarily the amount of pressure, it's actually where you're pressing,
It's,
or a combination of both.
well, it's a combination of both.
And as you described the hyoid bone, you said it's pretty high up in the neck, correct?
Yes, it is.
Okay. And here we saw that jaw or the mandible was fractured, and that is pretty close to the hyoid bone, correct?
That's correct.
Here you did not observe any type of ligature marks, like as if something like a rope or something had been tied around the neck, correct?
That's correct.
You did not notice any finger marks either, correct?
That's correct.
Now I want to spend a little bit of time going over the rest of your report. You spent a good amount of time on the cardiovascular system, is that correct?
Yes,
Okay. And you noted that he had 3 bypass grafts in his main coronary arteries, correct?
yes, I did.
You also noted that he had heart disease, correct?
Yes, he does.
You also noted he had aortic arteriosclerosis severe.
Yes,
And the aorta is responsible for carrying the oxygenated blood from the heart to the rest of the body, correct?
yes, it is.
You also noted in that same section that he had an enlarged heart, correct?
Yes,
Would you agree with me that someone with severe heart disease has a greater chance of dying during loss of blood compared to someone with a healthy heart?
just in general or in this case?
In general.
In general, yes.
Now, you testified that when someone's heart actually stops, the blood would stop coming out of the body. Is that correct?
Yes, or very minimally it would come out.
Okay. And I think you testified that you had not actually seen photos of the scene. You just see the person that is brought to you. Is that correct?
I did not go to the scene, but I did see
You
photos.
did see photos. And from those photos, you were able to determine that there was quite a bit of blood surrounding Mr. Murray, correct?
Yes, I do recall that.
Okay. So taking that with the evidence of finding blood in Mr. Murray's lungs, it was your determination that he was alive for a period of time, correct?
Yes.
After sustaining the injuries, I should say.
Yes.
You also testified that the injuries to the neck, which ultimately led to Mr. Murray's death, when Mr. Petrofessa asked you, could have been done by a 150-pound man, correct?
Yes, they could have.
If we were just looking at the binding with the duct tape, the binding on the wrists and the feet and the mouth, that would have not caused death without any other injuries, correct?
Correct.
I have nothing further.
Redirect.
Just briefly. We're in agreement that Mr. Murray didn't die of a heart attack. Is that correct?
That's correct.
Okay, and we're also in agreement that he was conscious during this attack up
Yeah.
until his heart stopped.
Up until he asphyxiated or lack of oxygen to the brain. Yes.
And there was a lot of blood at the scene.
Yes, as I recall.
And you've already noted that Mr. Murray was almost 300 pounds
Yes.
and he was 6 foot tall.
Yes, he was.
If Mr. Murray, when he was bound, wasn't just laying with his hands down at his side, not fighting back, then somebody would.
Sorry. Okay, wait a minute. You say that's a new one? No. Macrograms. You like, I just short. I made it real short. I didn't want to miss speaking. Sorry. I'm like all over the place today. This is too funny. All right, let me go back in here. I just wanted to make sure I said yes, no. I was just texting on a video with macrograms, right? Like she was just in the video, the Diddy video. And so I said hi to her over there, and then I see her over here. So I was just, don't worry. She know who I'm talking to. All right.
have direct access to that throat area, correct?
Yes.
But if he's fighting, if he's struggling, at that point in time, it would be very difficult because you're also dealing with the person that's struggling and fighting as you're doing that. Is that correct?
Yes, it would make it more difficult.
And once a neck compression starts to that throat, if somebody was to break that pressure as it was going on, even for 20, 30 seconds as they're struggling around, would that reset the clock of how you have to start again to inflict that injury to stop?
Yes, it would.
No other questions, Judge?
You want to follow up? No. Okay, all right. Come on up, lawyers, please.
So just so y'all where I am still watching the tweets, the judge has taken another break and they'll be back at 4. The state is now back presenting. So that's kind of where they're at in regards to the Diddy situation. And I'll bring y'all that as soon as, if I see anything, I'll definitely let you guys know. I know that his attorneys is asking for him to have the last word. And since we left out of there, I seen a reverend came up and spoke on his behalf, and I think that's the most thing that I've seen so far. So they letting the other jury come in. Okay.
Please be seated. Any other questions for Dr. Bryan?
No, Your Honor.
All right, Dr. Bryan, you may step down. And no objection excusing Dr. Bryan?
No objection, Your
All
Honor.
right, you are excused. Thank you for your patience. People next witness?
You can call Detective Conley.
Good morning. Raise your right hand and swear affirm the testimony you're going to provide is the truth, the whole truth, nothing but the truth, so help you God. All right, thank you. Please be seated and tell us your name.
Detective Jordan Conley.
Your witness.
And Detective, you spell your first name and your last name for us, please.
JORDANCONLEY.
And Detective Conley, where are you employed?
With the Oakland County Sheriff's Office.
And what's your current title?
I'm a detective out of the Rochester Hills substation.
And how long have you been a detective?
Just under 6 years.
Okay. And prior to being a detective, were you what were your duties?
I worked road patrol in Rochester Hills.
Okay. And how many years total do you have of law enforcement experience?
17.
17 years? Okay. And are you the officer in charge in this case that you've been here for all week?
Yes, I am.
Okay. And what does it mean to be an officer in charge?
You're assigned the case. You obviously, in a case of this magnitude, there's a lot more moving parts. On a normal case, you would do the full investigation yourself, all the way through delivering it to the prosecutor for review of charges. Obviously, in this manner, there's a lot more moving parts, a lot more detectives, and other people were involved. So usually I was a point of contact. As detectives did jobs, they would report back to me, or our command, who would then relay the information to me about what was obtained, what was found, information that I needed to be aware of in the case. As well as Detective Packmeyer, we'd heard earlier, he was assisting OIC in this matter. Once the evidence was collected and information was collected, it was submitted to the prosecutor's office, and we saw the case through all the way till we sit here today.
And how are you assigned to be an OIC in a case?
Through one of my command officers, whether it be our lieutenant or sergeant, is normal route of how I would be assigned.
Okay. And on this, do you recall when you were assigned to be the officer in charge of this?
The night of the incident, I don't recall if it was our detective lieutenant or detective sergeant, but I was advised that I would be OIC of the case and that Detective Packmeyer would be assisting me.
So would it be fair to say it's just luck of the draw at that point if you're working that day, things like that?
It's a decision that they made.
Okay. And were you, did you arrive on scene to the 3730 Newcastle Drive on the day of the homicide?
I did.
Okay. And were you initially dispatched there, or was that something you came to later on in the afternoon?
It was, we overheard the call while in the office over the radio. Obviously, there was multiple road patrol units heading to the area. I then got into my vehicle. I drove normal traffic as I have an unmarked vehicle, so I thought it would be, appropriate to drive normal traffic without lights and sirens in case the suspect vehicle was to be observed. I wouldn't be coming with all the lights and sirens to indicate that I was a police officer at that time.
And prior to arriving on scene that day, were you given the assignment of officer in charge, or did that just get handed down later?
No, that was handed down a little while into the incident. I don't recall exactly the time frame.
Okay. I'm going to jump ahead a little bit because we've heard a lot of testimony from Detective Packmeyer and some of the other detectives and deputies who did things in this case. I want to ask you a question. Does the Oakland County Sheriff's Office have a computer crimes division?
Yes, we do.
Okay. And what function do they serve in your role as an officer in charge investigating crimes?
As most of the time, if we have a cell phone that we view as evidence, computers, any electronic storage devices, they're able to examine those items, obtain information off of those items. We've also used them where they'll come to scenes and help with security footage. You know, a lot of times gas stations, other places with security footage, they don't even know how to use their own system or obtain the video off that. So the computers crime unit will come out, assist with obtaining, you know, videos such as that.
So during investigations, and if there's ring camera or surveillance video, and you would request their services to come out and help obtain any sort of digital media that would be necessary?
Yes, if it was something that was above our knowledge or ability, yes, we would.
Do you usually give them cell phones to examine or extract data from during your investigations?
Yes, it's very, very common in investigations. Everybody has cell phones on them. Everybody uses cell phones. Cell phone examinations very common in multiple investigations that I've completed.
Okay. And once you give them a cell phone, what do they give back to you?
Usually, sometimes if they find something that is blaring, they may just provide a report regarding that. Most of the time, they provide a USB, which has a program called Cellbrite on it. It essentially dumps all the information from the phone into that program. It's an exact, from what my understanding, it's an exact copy of what's on that phone, whether it's stored on the phone, recently deleted, some of that is still stored on the phone. It's a copy of what was on the phone, and you use this program to view through the items that were taken off of the phone at that time.
I want to follow up on a question that you said. Sometimes if something's blaring, they'll send it over to you. Is that what you testified to?
Yes, sometimes they do go through some things if you tell them that there's something very specific that you're looking for. And if they notice that item, they will contact you and send that item over.
So that was the next question. Sometimes, because the computer crimes aren't necessary, they're not the officer in charge, sometimes they go on scene. Do you give the cell phone examiner or the detectives at the Oak County Sheriff's Office certain parameters that you may be looking for in your investigation to speed it up?
It depends on the investigation. You know, obviously, if it's a child sexually abusive material case, you would indicate to them that that's something that you're looking for in this device. And, you know, obviously if they see images such as that, they would give you the heads up and indicate to you pretty quickly that that information is available.
So it'd be fair to say if you don't give them the certain parameters or certain things to look for, they just then give you an image or a copy of that particular cell phone in that Cellbrite software.
That is correct. I would receive a USB or hard drive and would have to go through all the contents of the phone myself.
And you were mentioning this Cellbrite. Is this a report mechanism or software that they then give you and you can review?
To be honest with you, I'm not. It's an application that comes on the USB, and that's how the information is viewed through that program.
So outside of how the software works or anything like that, that's not an area where you're on.
I don't have much knowledge beyond. That's the program that's on there, and that's what's used to view the contents of the phone.
So another question is, so is that Cellbrite program they give you, does that allow you to help search easier and things like that? It's just a report.
Yes, it has different tabs such as instant messages, chats, photos, videos. There's multiple different tabs that it breaks down the information into to make it a little bit easier to search. If you know you're looking for certain pictures, you can click on the photo and begin to go through the data that's in the images or photos. I forget how it's actually titled on the tabs.
Okay. But it's just an easily presentable thing for you to read and look at and search for information.
Yes.
Okay. And your knowledge and experience in your years in the detective bureau, do you know how many Cellbrite reports that you've gone through?
I couldn't even make a guess at this point. Probably 50 plus at least.
Okay. And as part of being the officer charged in this particular case that you're here for today, were you tasked with authoring and obtaining search warrants of cell phones?
Yes, I was.
Okay. In this matter, did you obtain a search warrant for defendant Joshua Zuazo?
Yes, I did.
Okay. And do you recall when you were able to obtain the search warrant?
I believe that search warrant was obtained on October 14th following him being taken into custody.
Okay. And so you drafted a search warrant for the cell phone. How did you know that cell phone that you were getting a search warrant for belonged to the defendant?
It was removed from him when he was taken into custody.
Okay. And after obtaining a search warrant for the phone, what did you do with this phone?
At that time, one of the computer crimes detectives, Detective Boyce, was actually at our office at the time. The cell phone was handed to me by the transporting deputy, Deputy Bander. I then took it, handed it to Detective Boyce from the computer crimes unit, who put it into a sealed bag and transported it to the computer crimes, their office, once I had obtained the search warrant and handed him a copy of the search warrant.
Okay. And once you gave that phone, or Detective Boyce took this phone, did you eventually get returned a Cellbrite extraction of the defendant's cell phone?
I did.
Okay. And when you were given this Cellbrite report of his phone, did you review that Cellbrite report?
I did.
And did it include text messages that you reviewed?
It did.
Okay. And this particular report, did you review text messages from Mr. Zuazo and Mr. Hernandez?
I did.
Okay. And how were you able to determine that was communications between Defendant Hernandez and Defendant Zuazo?
Through the investigation, obviously on the Cellbrite report, for that particular phone, it indicates the cell phone number, indicates who the owner is and what the owner number is. And through the text message conversations, both phone numbers are listed, who it's to, who it's from. And I recognize the other number as the phone number for Mr. Hernandez, specifically that he used when purchasing the signs, as we heard yesterday.
And you personally reviewed those messages?
I did.
Okay, give me 1 second. And of course, the computer. Okay. And at this time, Your Honor, the people are going to move to amend and publish People's Proposed Exhibit 23. There'll be text message between Mr. Hernandez and Mr. Zuazo. Those were previously given to both counsels.
Any objection?
No, Your Honor, I have received and reviewed all of those documents.
No objection. All right, 23 then.
Okay. And detective, this is going to bring it back to probably 9 minutes from elementary school. We're going to have to sit there and read through some of these, and we're going to ask you a question about these, okay?
Yes, sir.
And does that pop up on your screen right there?
Oh, yes, it did.
Okay, and this is a copy, or this is what a Cellbrite report will look like, an extraction report. Is that fair to say?
Yes, it appears to be an extraction report from Cellbrite.
Okay, is this the extraction report that you did for messages between Defendant Zuazo and Defendant Hernandez?
It's the one I viewed. I believe it's the one that was supplied to me by Detective Boyce.
Oh, Detective Boyce?
I believe he made the actual extraction report.
Okay, and so I see there's a little, I would say, column on the left that says participants. You see
Yes,
that?
sir.
Okay, and based on your review of other extraction reports, it lists the participants that are going to be in that particular messaging that you're reviewing.
Yes.
Okay, and what is that first name on there for the participant?
Joshua Zuazo _Zuazo 07 at iCloud.com.
Okay, and the way that's presented as the first name, is that the device where this particular messaging or the report is extracted from?
I'm not sure what order they would actually,
Okay.
the Cellbrite actually puts that in.
Okay, and you see the second one, it says, it's SOSO. And who do you know that to be based on your investigation of this?
Based on the phone number and through the investigation, that's the phone number used by Carlos Hernandez.
So the SOSO is Carlos Hernandez's phone number.
Yes, sir.
Okay, and that other participant is going to be that phone number. Who is that associated with?
I believe that's the actual device, the phone number that's for the device of Joshua Zuazo.
John, do you mind if I sit down so I can easily scroll through here? Okay. And just by reference, detective, this particular message, can we know who the sender is on this?
Yes, if you notice at the top, it says from, and then it gives a phone number and the contact name of SOSO, which in the participants was determined to be Carlos Hernandez.
Okay, And far as you know, I'm an Android user, so I'm not friendly and improved messaging. The colors would be different. Does the colors on this particular report, does that correspond to the type of device, or that's just the way Cellbrite does it?
I believe that's the way that Cellbrite does it.
Okay. And this message is coming from Defendant Hernandez to the phone number that you have associated with Defendant Zuazo.
Yes, as it indicates next to the phone number, it shows the designation as owner, which is the cell phone that we provided to obtain these messages.
Okay, and what does this message say that's coming from Defendant Hernandez to Defendant Zuazo?
It says, I know how to use a lockpick set, and I'm a get one.
And what is that dated?
That was September 16th of 2024. It appears to be 11:45 p.m.
Let's scroll down to some more messages, okay? And would this be the same person sending it and the same person receiving it, and this next set of message in the top left?
The blue one?
Yes.
Yes, it is the same sender and receiver.
And what is that saying?
That says we can get into some shit now.
And what is the response?
The response is from the owner phone, which was Mr. Zuazo says to Mr. Hernandez, and it states any lock ?
And the response from Mr. Hernandez?
Mr. Hernandez responds, any lock.
And the response?
Yes.
And this message, the one in blue right here, from Mr. Hernandez to Defendant Zuazo, what does that say?
We need a car.
What is that dated?
That's September 20th, 2024 at 7:21 p.m.
And the response?
Let me call the lot.
And the next group of message, and what does Defendant Hernandez say?
Okay.
And the response?
Mr. Zuazo states, he said no luck yet.
And what is the response from Mr. Hernandez in this message?
We have to have one.
Is that also day September 20th, or is that day September 20th, 2020?
That last message is September 20th, 2024 at 7:24 p.m.
And what does Defendant Zuazo say in this message in green right here?
He says, we may have to get one.
And what is the response from Defendant Hernandez?
It don't matter. We need one. However, we do it.
And the next message?
And possibly a dolly.
Excuse me, can we have clarification on who's the sender and possibly a dolly?
No issues with that. And on here, who is the sender of the message and possibly a dolly?
That appears to be a message from Mr. Hernandez to Mr. Zuazo.
And just for the record, all these messages here are going to be from Defendant Hernandez and Zuazo and vice versa.
I believe in so far that appears to what it should be, and according to the participants.
Okay. And going over several Cellbrite reports in your being a detective bureau, this is appears to be a text message containing some images. Would that be fair to say?
Correct.
Okay, and then during the full extraction, if we were to have a full extraction here, would it be fair to say you'd be able to click on it and the image could be either a thumbnail or a big image, depends on how bad it is.
Yeah, the images may have also been saved in the image folder, as your phone during messages sometimes takes snippets of images that are in messages and places it in different in places that would fall into the image folder when the Cellbrite and the phone number are done.
Okay, and Detective Conley, on this message that we're reviewing right here on your screen and up there, this message is being sent by who?
It's being sent by Mr. Hernandez to Mr. Zuazo.
Okay, and the date of this is?
This is October 4th, 2024. Looks like 6:00 p.m.
And this particular message, this text message, what does that display?
It displays DTE images that through the investigation were very similar to the images that were sent to him by Mr. Saucedo from the sign shop.
And this is, again, this is from Defendant Hernandez, Defendant Zuazo.
Yes, sir.
And then these up here, I'm not gonna have you guys read out loud since they're not relevant. What this, right here on, from Mr. Zuazo to Mr. Hernandez, the bottom one right here, what does it say?
Says Sam might be fired. No vehicle to work in. I'm finna go all in on something soon.
And this message right here on the top, who's sending this?
Mr. Hernandez to Mr. Zuazo.
And what does that say?
I promise you, bro, what we planning gonna be it.
Okay, and when was that sent?
That was October 6, 2024 at 2:25 p.m.
Thank you. And this next message, detective, what does it say? Let me scroll down.
This one's from Mr. Hernandez to Mr. Zuazo. It states, it's gonna get us where we need to be.
And when was that sent?
October 6, 2024 at 2:25 p.m.
Okay, what's the date of this message on the top right here?
You mean the top left?
Top left, yes, sir.
The date
Yes.
is October 9th, 2024 at 8:55 p.m.
Okay, and who's sending this message?
That's from Mr. Hernandez to Mr. Zuazo.
And what does that say?
I'm about to leave now.
Okay, and what about the response? It would be the response from,
Mr. Zuazo to Mr. Hernandez is okay.
and that's October 9th.
That's October 9th, 2024 at 8:55 p.m.
And the next message down here at the bottom of this page, what does that say?
That's from Mr. Hernandez to Mr. Zuazo. It states, you ready.
Okay, that date in the bottom, what date is that?
That's October 10th, 2024.
Okay, and what time is that?
That's 8:20 a.m.
So this is communications the night before the homicide in Rochester Hills between Mr. Zuazo and Mr. Hernandez.
Yes.
Excuse me, was it the time in the evening or the morning of the?
Is it? I'll clarify that. Is that 8:20?
That's 8:20 a.m.
AM.
Thank you. And this message in the top right from Mr. Zuazo, what does he state here?
I already ate.
Okay, and this next message, would that also be Mr. Zuazo to Mr. Hernandez?
Yeah, that one is Mr. Zuazo's to Mr. Hernandez. I specifically do recall that as being a property release form, which Deputy Haglin also indicated he had found at Mr. Hernandez's house during the search warrant.
In this image that we have here through the cell phone.
While in the program, I was able to observe that image at full size.
Okay, and you've been sitting here for the last couple of days, would that be fair to say?
Yes, sir.
And that is that one of the exhibits that people had admitted through Detective Haglin regarding something that he found during the search
Yes,
of
sir.
Hernandez's house.
Yes, sir.
And this message right here, what's the date on this?
That is October 10th, 2024 at 4:35 p.m.
And that's a copy that you saw of that release form.
Yes, it was a release form similar to the paperwork that I don't know if it's the exact physical copy that was found, but it's similar to the ones that were located at Mr. Hernandez.
Okay, and based on your knowledge, that particular piece of paper that we admitted as an exhibit through Detective Haglin, that was found at the house that Mr. Hernandez and Man Diaz were staying at in Lincoln Park.
Yes, from his testimony yesterday. Yes, sir.
And this particular message, though, is a copy of that image that's sent from Defendant Zuazo to Defendant Hernandez.
Yes.
And this message right here in the top left in the blue, can you?
That's from Mr. Hernandez to Mr. Zuazo. It states, what is this? And that's on October 10th, 2024 at 4:55 p.m.
And this next message in the green, what is this?
Mr. Zuazo to Mr. Hernandez states waiver of damages. That's October 10th, 2024, 4:58 p.m.
And this next message in blue,
Mr. Hernandez states to Mr. Zuazo, that's for a landlord though. Read it. That's October 10th, 2024, 4:58 p.m.
And this one in top right, can you read that first?
Mr. Zuazos to Mr. Hernandez. I get that. Just giving you an idea in case they refuse. Something else to sign. October 12th or October 10th, 2024, 5:01 p.m.
And the next message.
Mr. Hernandez writes to Mr. Zuazos, the light's working. October 10th, 2024, 5:47 p.m.
And then next message over here.
Mr. Zuazos states to Mr. Hernandez, the baby has my phone, so just call it back to back and he'll give it to me. October 10th, 2024, 6:02 p.m.
And the next message that we have here.
Mr. Hernandez states to Mr. Zuazos, okay, October 10th, 2024, 6:02 p.m.
And based on your reading of Cellbrite reports, I see that it says message deleted reason. Do you know what that is?
I don't have exact knowledge of that as my understanding of Cellbrite and the way phones store data is sometimes you think you deleted something and your phone actually stores it in a separate location that can be extracted for some time, but I can't exactly testify to the fact of where these messages were located in the phone.
Thank you. And the next message.
Mr. Zuazos states to Mr. Hernandez, or beep, October 10th, 2024, 6:02 p.m.
And the next message.
Mr. Zuazos states to Mr. Hernandez, both, October 10th, 2024, 6:02 p.m.
Okay. And before I go down to the next message, based on your investigation, was there people who came to the Murray's residence on October 10th?
Yes,
Do you recall about what time that was?
I believe it was somewhere, I believe I was after 9 o'clock, before 10 o'clock, somewhere in that area. I would have to actually review the ring footage to see the actual timestamp of their exact.
But these messages between defendants, this would be before the time that the DTE workers or the people who were dressed up as that came to that residence in Rochester Hills.
These last messages that
Yes,
were
sir.
just read, yes, that is prior to that time period.
And this next message, what's the date and time on that?
The date and time on that is October 10th, 2024 at 11:05 p.m.
And who's sending this message?
That's Mr. Hernandez to Mr. Zuazos.
And what does that say?
States home, bro.
And what about this next message, detective?
That's Mr. Zuazo to Mr. Hernandez. Good shit. That's October 10th, 2024 at 11:06 p.m.
And as the officer in charge, would that be after the time? Do you remember if this is after the time that the ring video that we reviewed on October 10th at the Rochester Hills?
Yes, that's after the time period.
And this next message, detective, what time is this at? Date and time?
That one is October 10th, 2024 at 11:06 p.m.
And what does that say?
It appears to be a time. It's from Mr. Zuazos to Mr. Hernandez and states 8:45.
And the next message?
Mr. Hernandez to Mr. Zuazo, okay, and that's on October 10th, 2024 at 11:06 p.m.
And Detective Connolly, this next message right here in the middle, what time is that?
The date and time on that one?
Yes, sir.
That one is October 10th, 2024 at 11:20 p.m.
And who's this message from and to?
That's from Mr. Hernandez to Mr. Zuazo. It states, am I picking you up at 8:45 or you want to be out there by 8:45?
And that's from Defendant Hernandez to Defendant Zuazo.
Yes.
And this next message, detective, what does that say?
That's from Mr. Zuazo to Mr. Hernandez. That says, be here at 8:45.
What's the date and time on that?
That one is October 11th, 2024. That's at 2:35 a.m.
This next message right here at the top in the blue. Can you, the date and time of that, please?
That is October 11th, 2024, 8:47 a.m.
And who is that to?
That's from Mr. Hernandez to Mr. Zuazo. And that says, on my way.
And this next message right here in the green, detective.
That's from Mr. Zuazo to Mr. Hernandez says, I'm up, and that is on October 11th, 2024 at 8:47 a.m.
And the next message, sir.
For Mr. Hernandez to Mr. Zuazo says, okay, and that's October 11th, 2024 at 8:48 a.m.
And October 11th, 2024, that's the date of the death of Mr. Murray.
Yes, sir.
And while you were sitting here in the courtroom and while you reviewed all the evidence as officer in charge, were you aware of that Lowe's surveillance video that was admitted as exhibit?
Yes, sir.
Okay. And this date and timestamp, was that before that Lowe's home video date and timestamp?
Yes.
And also, as part of your investigation, did you obtain a cell phone that belonged to Amanda Diaz?
That was obtained by Cato Parish and transported back up here when Detective Wendell Smith and Detective Weedman went down and picked up the property.
Okay, and as the officer in charge, did you author or request a search warrant for that phone?
That one I believe Detective Weedman did because there was some logistics where we weren't sure when we were going to be able to get the property. So he had initially authored one for Cato Parish to do a search of the phone. Then a secondary one was authored when it was determined that we were going to be bringing it back in a timely manner.
And was that phone searched pursuant to a valid search warrant here in Michigan?
Yes.
Okay. And did you give the cell phone in the same course and manner that you gave defendant Zuazo's phone over to the Oakland County?
That one came in a little bit different because in the they arrived back from Louisiana after driving for hours in the middle of the night. So detectives logged all the property into our property room. Those items were later picked up from the property room and transported over to the computer crimes unit by us.
Was a full cell phone extraction done of Mrs. Diaz's cell phone?
Yes,
Okay. And did you review that cell property report of Amanda Diaz?
I did.
Okay. And did you go through that phone and review messages between Mr. Hernandez and Mrs. Diaz?
I did.
Your Honor, at this time, the people are going to move and admit people's proposed exhibit number 22 at this time, Your Honor.
I have no objection, got it?
No, it's not.
And Detective, we're going to kind of have to do the same thing, okay?
Yes, sir.
Up here, this is a copy of the cell phone extraction report that was given to you or created in this for Mrs. Diaz's cell phone.
Yes.
Okay. And who are the participants in this particular cell phone extraction that we're going to go through?
The first one is a contact of and it is the phone number for Carlos Hernandez.
And that's the same cell phone number that we were just reviewing messages between the defendants.
Yes, sir.
Okay. And who is this other participant
The other one is the owner phone, which was the phone known to be Amanda Hernandez's, or Amanda Diaz, which was taken in or seized while in Cato Parish.
Okay. And this first message on the top, do I have to do it the same manner? Who is this to and who is this from?
This is from Mr. Hernandez to Amanda, states baby.
Okay. And then the next one?
That's from Amanda to Mr. Hernandez, states, yes, my love.
And this, these next three right here, would this be fair to say, are these from Miss Amanda Diaz to Mr. Hernandez?
Yes, they appear to be.
And what does the first message say?
States, but I got a free Jackson.
And then the next one?
Guess what?
Okay. And this next one, can you give me the date and time on this one right here?
That is October 1st, 2024 at 1:46 p.m.
And who is that from?
That's from Amanda to Mr. Hernandez.
And what does that message say?
The badges were delivered.
And the next message?
You account still negative, and that's from Amanda to Mr. Hernandez on October 1st, 2024 at 1:50 p.m.
And then this next message, kind of same procedure, date and time.
That one is on September 28th, 2024 at 11:57 a.m. That's from Amanda to Mr. Hernandez. It states, remember what I said. If you have to leave with nothing, that's okay. You're the most important.
And what's the next message?
The next message is from September 28th, 2024 at 11:58 a.m. from Amanda to Mr. Hernandez, says, what if he's not home?
And what about the next two messages? Is that responses from Mr. Hernandez to Mr. Diaz?
Yes, it's from Mr. Hernandez to Amanda. The first one states, I know, baby. The second one states, he will be.
And what about this message up in blue right here?
That's from Mr. Hernandez to Amanda on September 28th, 2024 at 11:58 a.m.
And what does that say?
I'll text you when we make it up there.
And what about this next one in green?
That one's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 11:58 a.m. Says, as long as you know your life and freedom is important to me.
And technically, what about the next one?
That's from Amanda to Mr. Hernandez on September 28th, 2024 at 11:58 a.m. States, okay, baby.
And what about this next one? Detective?
The next one's from Mr. Hernandez to Amanda. That's going to be September 28th, 2024 at 12:08 p.m. Says, I know it is, baby.
And can you read this next message?
The next one's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 12:29 p.m. Says, I'm gonna have to buy a hoodie. This weather ain't it.
And the next message is not a response. And then what about this next message, the date and time?
That one is on September 28th, 2024 at 12:44 p.m. from Amanda to Mr. Hernandez. States, turn your phone off when you're out there, just in case.
And what's the next message?
The next one's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 12:45 p.m. States, or you think you don't need to.
And technically, can you read the top message for us?
That's from Amanda to Mr. Hernandez. That's on September 28th, 2024 at 1:31 p.m. States, I'm so nervous, but you guys seem to have it down. And I feel better now that you have a good getaway car.
What's the next message? Exactly?
Next one's from Amanda to Mr. Hernandez on September 28th, 2024 at 1:36 p.m. States, I still am really nervous though.
Detective, next one, please.
That's from Mr. Hernandez to Amanda. That's on September 28th, 2024. That's at 1:40 p.m. Mr. Hernandez states, it's going to be okay.
And what about this next one? Right?
That one's from Amanda to Mr. Hernandez on September 28th, 2024 at 1:40 p.m. Amanda states, promise.
And can you read the next message?
That one's from Amanda to Mr. Hernandez on September 28th, 2024 at 1:57 p.m. States, I've been creeping on you.
And the next one?
That's from Amanda to Mr. Hernandez, September 28th, 2024 at 2:09 p.m. That one states, make sure you don't forget to take the tag off.
Okay. And what about the next one?
That one's from Mr. Hernandez to Amanda on September 28th, 2024 at 2:39 p.m. It appears to be we FKD up.
And the next one? Sorry. In this next one right here.
Amanda writes to Mr. Hernandez, what? And that's on September 28th, 2024 at 2:39 p.m.
And this top message here in blue?
That's from Mr. Hernandez to Amanda. That's going to be on September 30th, 2024 at 1:03 a.m. I am, baby.
And this next message, detective.
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:03 a.m. And it states, and make Yogi take it. Don't be doing all the work.
And based on your investigation in this case, detective, were you made aware of a stolen vehicle from Dearborn Heights?
Yes, the vehicle that was located burned out in Detroit, as we had heard from Mr. Keelan earlier, was stolen between the time of late the evening of September 29th and the early morning on September 30th.
And this message from Mrs. Diaz to Defendant Hernandez says, and make Yogi take it and don't be doing all the work.
Yes.
And Detective, can you read this text message right here in the middle?
Yes, that's from Amanda to Mr. Hernandez. That's going to be on September 30th, 2024 at 1:05 a.m. States, makes me mad. It's all on you because you're the brains and then the message ends.
And what about the next one?
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:15 a.m. States, where you appears to be going, it's misspelled, to get a.
And this next message up here in the top right.
It's from Amanda to Mr. Hernandez on September 30th, 2024 at 1:18 a.m. States, okay, just be careful. I'll be in the living room.
And the next message, Detective.
That's from Mr. Hernandez to Amanda on September 30th, 2024 at 1:18 a.m. Says, okay, I love you.
And the next message in the right here in the green.
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:18 a.m. States, I love you more, husband.
Hey, Detective, do you read that last message right here in the bottom right here?
That one is from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 1:42 a.m. That message states, I know you not gonna take a actual DTE car.
And can you read this message?
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 2:05 a.m. States, you good, baby? Question mark.
And what about the next one?
That's from Amanda to Mr. Hernandez. That's September 30th, 2024 at 2:29 a.m. I'm going to go to sleeps.
And Detective, this message right here in blue, can you do that for us?
That's from Mr. Hernandez to Amanda. That's September 30th, 2024. It'd be at 2:43 a.m. States, we just got a car.
And this time that stands here on September 30th, does that correspond with the reporting from the Dearborn Heights police report that you guys were?
Yes, it's within the time period that the vehicle was seen and then found to be gone.
And he says, we just got a car.
Yes.
And this next message right here in the green?
That's from Amanda to Mr. Hernandez on September 30th, 2024 at 2:43 a.m. States, are you okay?
Can you read this next message?
That's from Amanda to Mr. Hernandez on September 30th, 2024 at 2:43 a.m. States, you driving our car? Question mark.
And what's the response?
For Mr. Hernandez to Amanda on September 30th, 2024 at 2:43 a.m. He responds, yes and yes.
And can you go ahead and read the one in the green?
That's from Amanda to Mr. Hernandez. That's on September 30th, 2024 at 2:44 a.m. States, could you please move the cursor? Thank you. You sure there was no cameras around?
And what is the next response?
Mr. Hernandez responds with, yes, I'm sure. That's September 30th, 2024 at 2:46 a.m.
And these next messages, these are just these are just messages from Ms. Diaz to Mrs. Hernandez, or to Mr. Hernandez.
They appear to be.
And were these particular messages just about mundane marriage things?
Yes, appear to be.
And this message here in the blue, can you read that?
That's from Mr. Hernandez to Amanda, that's on September 30th at 2024 at 3:07 a.m. states about to take Yogi home now.
Let's skip this. This was out of place. And then this message right here. That one in the group.
That's from Amanda to Mr. Hernandez. That's October 1st, 2024 at 2:28 p.m. What else you got to do?
And then what about the response?
Mr. Hernandez to Amanda responds, get this shit. That's October 1st, 2024 at 2:28 p.m.
And what is the response in the green?
Amanda states to Mr. Hernandez, what shit? That's October 1st, 2024, 2:29 p.m.
This next message down here in the blue what is that?
That's from Mr. Hernandez to Amanda, states the signs. That's October 1st, 2024 at 2:29 p.m.
So just breaking news. I think this is breaking news. I think that they are giving him, weighing all the relevant factors. The court determines that the sentence is 50 months of incarceration. I just seen it. So the judge said that a sentence over 11 years is not reasonable. Even the probation department recommends a sentence less than half of that. But 14 months time served would not be sufficient. So he gave him 50 months. So Diddy has officially received 50 months. So what is 50? Look, I got to get my calculator out, y'all. I'm not good at math. 4 years. He got a little bit over 4 years. Yikes. How much time do you have to serve? Let me see. I don't know how much what you got to do. Is it 80% of your fed time? Well, 4 years is not bad. 4 years is not bad. Not for what he did. They do 85%. Okay. 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 He has been in prison a little bit over a year. Okay. You know, a lot of people were saying that they probably meet halfway in the middle of this. Yeah, so it's 50 months minus time served. So what he got about? I mean, I can live with that. I can live for that. But the judge I don't think the judge was being nice at all. The judge wanted him to be, he said, shoot, time served ain't gonna cut it, boo. My dude, that ain't gonna cut it. He even mentioned some stuff about the, in his words. So yeah, I mean, because the judge even got very explicit things in his when he was speaking to Diddy about the Essen and yeah, he has 50 months with time. I guess you got to subtract time served. I didn't see that part. I just seen the 50 months so far, but I'll go back in there and see if they. I'm assuming it got to be with time served. Yeah, let me see. Okay, so he been in jail for 13 months, just so y'all know. I wonder how the courtroom doing. Let me see. Let me get back to my guy that I be watching. Our guy, Inner City Press. Okay, so the judge asked his lawyer any recommendation where to serve the sentence. Combs' attorney says, can we get back to you on Monday now that we know there is a sentence? So I guess they got to figure out where he's going to be sentenced. He was sentenced to 50 months of incarceration by the judge. That will be minus the 14 months he already served. So just so y'all know. So they saying he'll be out in like 2.5 years. What y'all think? Yeah, he wasn't never going to Miami. They be doing too much, man. I don't believe that. Because I know he wasn't banking that he was just gonna get out like that. Well, that's a lot different than 11 years. That's what I'll tell you. Now, when they was talking about 11 and people was throwing out football numbers like 20, I'm like, man, I just can't stand on that. Okay. All right, back to our trial. We'll cover more of that later on tonight.
These messages have nothing in here.
There was no content in the subrate to those indicated.
And this one down here in the bottom, can you read that for us?
On October 3rd, 2024 at 5:55 a.m., Amanda writes to Mr. Hernandez, you're probably going to have to move that truck. Laugh out loud. She's like, that's not stolen, is it?
And can you read this message right here on the top, detective?
That's from Amanda to Mr. Hernandez on October 3rd, 2024 at 5:55 a.m. States, I told her it was Yogi's.
I'm not going to read these two. And detective, this one on top here, can you read this one?
Amanda writes to Mr. Hernandez, how much money do you have, baby? That's October 3rd, 2024 at 3:45 p.m.
And then can you read the next one in this chain?
The next one's from Amanda to Mr. Hernandez on October 3rd, 2024 at 5:13 p.m. States, did you make sure the tracker is out of that truck?
And then can you read these next two messages and give us a date and time?
Amanda writes to Mr. Hernandez on October 3rd, 2024 at 6 p.m. I love you, baby.
And can you read this top one, please?
Amanda writes to Mr. Hernandez on October 3rd, 2024 at 7:13 p.m. OMG, or oh my God.
And what is the response here?
Mr. Hernandez to Amanda is what's wrong, baby? That's October 3rd, 2024 at 7:17 p.m.
And what's right, this one right here, date and time. Can you read this for us?
That's from Amanda to Mr. Hernandez on October 3rd, 2024 at 7:24 p.m. Says, you got to move the truck so we can take the garbage out.
And then this message on top.
Amanda writes to Mr. Hernandez, what do you need it for again? October 4th, 2024 at 6:26 p.m.
And then the next message that's down there.
Mr. Hernandez writes to Amanda on October 4th, 2024, 6:26 p.m. to make the pages and the badges.
And then the response from Mrs. Diaz.
Amanda to Mr. Hernandez, okay, October 4th, 2024 at 6:26 PM.
And then this one on top here.
That's Amanda to Mr. Hernandez. That's October 6th, 2024, 8:53 PM. States, I'm worried.
And then what is the response here include?
Mr. Hernandez to Amanda, about what? October 6th, 2024 at 8:53 PM.
And what about the responses, Green?
Amanda states to Mr. Hernandez, our house, October 6th, 2024 at 8:53 PM.
And of course, the next question I ask you, what about the blue one at the bottom?
That's from Mr. Hernandez to Amanda, states it's okay, October 6th, 2024 at 8:53 PM.
And the top one, sir?
Amanda to Mr. Hernandez, you sure, October 6th, 2024 at 8:53 PM.
And what about this response in blue?
That's Mr. Hernandez to Amanda, trust me, it's okay, October 6th, 2024, 8:53 PM.
And can you read this top one?
Amanda to Mr. Hernandez, well, we are only 5 days late on rent, not too bad, ANF, it's 7:54. And that's October 6th, 2024 at 8:54 PM.
And then what about this message right here in the green?
That's from Amanda to Mr. Hernandez, October 6th, 2024, 8:55 PM. It states, we just spent too much money in PR. That's what fucked us.
And what about this message here in blue down the bottom?
That one's from Mr. Hernandez to Amanda, states, yeah, but it will be okay. Them things will be ready tomorrow, and then we can go do that. That's October 6th, 2024 at 8:56 PM.
And then can you read this top one?
That's from Mr. Hernandez to Amanda. I don't know either. That's October 7th, 2024, 9:51 PM.
And the next one?
Amanda to Mr. Hernandez, you sure you don't need anything else, baby? That's October 8th, 2024 at 12:04 AM.
And what about that next bottom?
Mr. Hernandez to Amanda, I don't think so. Them badges would be nice. That's October 8th, 2024 at 12:04 AM.
And then can you read this bottom one here in green?
That's from Amanda to Mr. Hernandez. Yeah, but I don't know how to make that. Plus, I don't think you need it. I'll look it up. That's October 8th, 2024 at 12:04 AM.
And then right here, this message right here in green, in the middle, the one is dated October 8th, 2024. When you were reviewing the cell phone, did you make any notes of this particular text message? Do you recall?
I believe that was a link due to the computer that we have to use to usually view the Cellbrite program. It's not connected to the internet because a lot of times cell phone dumps are used for incidents with child sexually abusive material. So I'm not able to click on that link, but I do recall there being photos inside the phone that showed ID badges.
And can you just read off what that?
That's from Amanda to Carlos. The information in the message states custom ID badge, personalized employee photo identification card, customized plastic ID card for office worker, doctor, nurse, student / no punch hole. And that's on October 8th, 2024 at 12:06 AM.
And then what is this next message here?
That's from Mr. Hernandez to Amanda. Says something like that with no pictures. October 8th, 2024 at 12:06 AM.
Okay. And this top message here in blue, can you read that for us?
That's from Mr. Hernandez to Amanda on October 8th, 2024 at 12:07 AM. States, takes too long to ship. I'm trying to be gone by Thursday.
And That was October.
That was October 8th, 2024 at 12:07 a.m.
Okay. And do you recall what day of the week October 11th of 24 was when you arrived to the house?
I believe that was a Friday.
Okay. And so the night before on 10th, when you reviewed the ring camera, that would have been a Thursday.
Yes.
And can you read this message right here in the middle after that blue one?
That's from Amanda to Mr. Hernandez. States, wait, I just needed the link to open my Amazon. That's October 8th, 2024 at 12:08 a.m.
And this one right here in blue, can you read that for us?
That's from Mr. Hernandez to Amanda. States,
Wait a minute. Well, wait a minute. Just Shamrock. Oh my goodness. Thank you. Thank you. Oh my goodness, y'all. Oh my. Look, wait a minute. I was like, I just stepped away. I said, let me go use the restroom. And I come back and I'm like, okay, I see Mommy and Me, Dr. Mommy and Me podcasting here. And I'm like, what is going on? And then I see all of 20, just Shamrock. Thank you, thank you, thank you. Oh, wow. Oh, wow. Yes, and I'm so glad that people, as they're seeing them, they're coming in and they're saying, thank you, thank you, thank you. Yay, that is amazing. Oh, wow. I was like, let me get back. Wait a minute now. Like, what is going on? Welcome, welcome, welcome to all the new members. Thank you so much, Just Shamrock. Oh, well, y'all know I get to crying and stuff. Y'all better stop trying to make me cry. Just Shamrock, you trying to make me cry today when I got to be a gangster tonight to go against Barbara. Like, I'm trying to get all my gangster skills on, and she trying to make me cry. I can't deal. Oh, wow. Thank you so much. Oh, that is amazing. Let me update this banner. Wow. Y'all looking, we up here looking at this this unalivened by text message by these two goofballs. I know, right? SD, like I probably be cutting. I gotta get my gangster back on. Y'all are making me Just Shamrock making me be a sucker out here in these streets, and I got this great debate coming on tonight. I got to get my muscles back together so I can bring these guns for Barbara. I got to be able to get it. Oh, that is so amazing. I truly, truly, truly appreciate it. And welcome to all the new members. Welcome to Take It to Trial, the Drama Club. Let's go here. Okay, let me get us back in here because I think that they gonna be doing closing arguments and stuff, and this is going to the jury today, y'all.
it's okay, and make one for Yogi. Do his name as Jonathan Wright. That's October 8th, 2024 at 12:12 a.m.
And then what about this one here in blue?
That's from Mr. Hernandez to Amanda. States, make him an inspector too. October 8th, 2024 at 12:12 a.m.
And what about the next message?
Amanda states to Mr. Hernandez, I did. That's October 8th, 2024 at 12:12 a.m.
And this message, these two messages, Blue, can you go ahead and read those?
Both are from Mr. Hernandez to Amanda. The first one states, okay. That was on October 8th, 2024 at 12:13 a.m. The second one states, did you print them? Same date at 12:13 a.m.
can you read the top message and the other blue one underneath that as well?
That's from Mr. Hernandez to Amanda. States it's BS. That's October 8th, 2024 at 1:10 a.m.
And what about the next one right here?
That's from Mr. Hernandez to Amanda. States, but we will be leaving soon. October 8th, 2024 at 1:10 a.m.
Okay, and we just won the green that's right here in the middle.
That's from Amanda to Mr. Hernandez. States, I know, baby, but I don't want you rushing this. I don't want anything happening to you. October 8th, 2024, 1:11 a.m.
And what about this message in the blue one?
That's from Mr. Hernandez to Amanda. States, it's going to be okay. October 8th, 2024 at 1:12 a.m.
And the second is top one in the blue. Can you read that for us?
It's from Mr. Hernandez to Amanda. States, I hope we get enough money to buy a house. October 8th, 2024, 1:14 a.m.
What about this next message in green right here?
That's from Amanda to Mr. Hernandez. Me too, baby. Our own home. October 8th, 2024 at 1:15 a.m.
What about this next one here in green?
On the same date and time, she also writes no rent. And that's Amanda to Mr. Hernandez.
And what about the response?
Mr. Hernandez on the same date and time from Mr. Hernandez to Amanda. Yes.
And can you read this one in blue?
That's from Mr. Hernandez to Amanda. States, if what I feel is here, we gon' be good. October 8th, 2024 at 1:16 a.m.
And what's that response in green?
That's from Amanda to Mr. Hernandez. That's on the same date and time. She replies with, so we can have a nice backyard.
And we read this one, the green one down in the bottom for us.
That's on the same date and time. That's from Amanda to Mr. Hernandez. States, I know I'm like, I wonder what's there.
And then, all right, read those. What's this down here? This blue one. Can you give us a read that? Give us a date time of that.
That's from Mr. Hernandez to Amanda. That's on October 9th, 2024 at 9:17 p.m. States, okay, just pulled up to Yogi's.
And what about this message here in green?
That's from Amanda to Mr. Hernandez. States, okay, baby, don't be long. You need to do the truck and sleeps. That's October 9th, 2024 at 9:17 p.m.
And can you read the one in blue?
That's Mr. Hernandez to Amanda on October 9th, 2024 at 9:18 p.m. States, I know.
And what is the response in green?
Amanda responds on the same date and time. Be safe.
And what about the message in blue?
That's from Mr. Hernandez to Amanda. States, always am. That's October 9th, 2024 at 9:19 p.m.
Okay. And this top message right here, can you read that for us?
That's from Amanda to Mr. Hernandez. States WYD love, commonly known, what are you doing? That's October 10th, 2024 at 7:09 p.m.
And this message in blue, can you read that for us?
That's from Mr. Hernandez to Amanda. States he's grabbing weed, then we coming back to get the truck. That's October 10th, 2024 at 7:10 p.m.
Okay. And as you also chart, this time is corresponding before when they appear on the Murray's porch on October 10th in the evening.
Yes, a couple hours prior.
Especially in green. Can you read that for us?
That's from Amanda to Mr. Hernandez. States, okay, baby, you ready and got your head ready? October 10th, 2024 at 7:10 p.m.
And what about this message in blue?
That's from Mr. Hernandez to Amanda, states yes. That's October 10th, 2024 at 7:10 p.m.
This one in green, please.
Amanda to Mr. Hernandez, just be careful. October 10th, 2024 at 7:11 p.m.
And what about this message in blue?
Mr. Hernandez to Amanda, I am. October 10th, 2024 at 7:11 p.m.
And message in green.
Amanda to Mr. Hernandez, promise. That's the same date and time.
And what about this one in blue?
Mr. Hernandez to Amanda states promise. October 10th, 2024 at 7:19 p.m.
And message in green.
Amanda to Mr. Hernandez, I love you so much. October 10th, 2024 at 7:22 p.m.
And what about the response in blue?
Mr. Hernandez to Amanda, I love you too. October 10th, 2024 at 7:36 p.m.
What about this message right here in green where my cursor is?
Amanda writes to Mr. Hernandez, you guys are gonna go this late. That's October 10th, 2024 at 7:43 p.m.
And what's the following message?
That's Amanda to Mr. Hernandez, states, remember what I said. Shit seem weird. GTFO, commonly known as get the fuck out. That's October 10th, 2024 at 8:14 p.m.
And then right here on top of the green.
Amanda to Mr. Hernandez, promise. That's October 24th or October 10th, 2024 at 8:15 p.m.
And that this message was after that last message we said that if it looks weird, get out of there.
Yes.
Okay. And what about this response in blue?
That's from Mr. Hernandez to Amanda, promise.
And what is the response from Mrs. Hernandez?
Amanda to Mr. Hernandez, I love you always. That's on October 10th, 2024 at 8:16 p.m.
And this one right here, Fluff Detective.
That one's from Mr. Hernandez to Amanda, states, I love you too. Let me get into work mode. October 10th, 2024 at 8:16 p.m.
And this one on top.
That's Mr. Hernandez to Amanda. I'll call you when we done. October 10th, 2024 at 8:16 p.m.
And what about this message in green?
That's from Amanda to Mr. Hernandez, states, wear a mask when you get close. October 10th, 2024, 8:16 p.m.
And then what's this message here in green?
Amanda to Mr. Hernandez, okay. October 10th, 2024 at 8:17 p.m.
And what is this message right here?
That's Mr. Hernandez to Amanda, says, I got it on now. October 10th, 2024 at 8:18 p.m.
And again, is this message, this communications before the Ring video camera that?
Yes, it appears to be a little bit prior to that.
Can you read this top one for us, please?
That's from Amanda to Mr. Hernandez, says, okay, baby, get your head good. October 10th, 2024 at 8:19 p.m.
Can you read the next one, please?
From Amanda to Mr. Hernandez, states, you put the magnets on. October 10th, 2024 at 8:22 p.m.
Next message.
Amanda to Mr. Hernandez, sorry, just checking. October 10th, 2024 at 8:22 p.m.
And the message in blue detective.
That's from Mr. Hernandez to Amanda, states yes. October 10th, 2024 at 8:27 p.m.
Can you read this top message right here?
It's from Amanda to Mr. Hernandez, says, I love you too. October 10th, 2024 at 8:28 p.m.
And what about this bottom message down here? This one in blue.
That's from Mr. Hernandez to Amanda, states 216 Greendale, October 10th, 2024 at 8:41 p.m.
In this message, there's no list of city. Is that fair to say?
Correct.
Okay. And during your investigation, did the Greendale address become of significance to you?
Yes, it was in the general area of where the vehicle was burned. Also, we had obtained video from, I believe the address was 90 Greendale and Highland Park.
Okay. And this next message right here in green, can you read that for us?
That's from Amanda to Mr. Hernandez. That states, that's where I go get the food. That's October 10th, 2024 at 8:41 p.m.
And the next message, sir.
Mr. Hernandez to Amanda, yes, October 10th, 2024 at 8:41 p.m.
And can you read this top one for us?
It's from Amanda to Mr. Hernandez, states okay. It's October 10th, 2024 at 8:42 p.m.
What's the next message say?
That's from Amanda to Mr. Hernandez, states, are you done? It's October 10th, 2024 at 9:28 p.m.
And this message in blue?
That's Mr. Hernandez to Amanda, states no. That's October 10th, 2024 at 9:29 p.m.
And the next one, sir.
That's from Amanda to Mr. Hernandez, states what happened, October 10th, 2024 at 9:29 p.m.
And would this date and time correspond to after the two people who appeared on the Murray's doorstep left on the?
I believe that's slightly after or right in the time frame. I would have to view the video to see the actual timestamp.
What does this top message say?
That's from Mr. Hernandez to Amanda, states, I'll tell you when we get there.
And when's that date?
October 10th, 2024 at 9:29 p.m.
And the next message?
That's Amanda to Mr. Hernandez. You need me to pick you up. That's October 10th, 2024 at 9:29 p.m.
And what about this next one?
That's from Mr. Hernandez to Amanda, states, yes, we did good though. That's October 10th, 2024, 9:29 p.m.
And the next message, Detective?
Amanda to Mr. Hernandez, okay, should I leave? That's October 10th, 2024 at 9:30 p.m.
And can you read this message on top?
That's from Amanda to Mr. Hernandez, says, where do I park to get this food? That's October 10th, 2024 at 10:01 p.m.
And the next message?
8074 Homer. That's October 10th, 2024 at 10:04 p.m.
And was this address at all significant to you?
I don't recall that address being significant or any evidence coming from that specific address.
And then this message right here, can you read the one in green?
That's from Amanda to Mr. Hernandez, states, I just seen a hooker.
And what's
October
the-
10th, 2024 at 10:07 p.m.
And the next response was?
It's from Mr. Hernandez to Amanda, laugh out loud, October 10th, 2024 at 10:07 p.m.
And then can you,
That's Amanda to Mr. Hernandez. Be there in 12 minutes, October 10th, 2024, 10:07 p.m.
and that would have been after the October 10th
Yes.
video. Okay. And this next message, can you read that in green?
That's from Amanda to Mr. Hernandez. Wait, don't leave yet. And that's October 11th, 2024 at 9:02 a.m.
And the next message?
That's Mr. Hernandez to Amanda. I already left. October 11th, 2024 at 9:16 a.m.
And this message in green right here, Detective.
That's Amanda to Mr. Hernandez. That was before I came upstairs. Laugh out loud. October 11th, 2024, 9:17 a.m.
Can you read the top one?
Amanda to Mr. Hernandez. I know. Hello. LMAO, which is commonly known as laugh my ass off. I saw you leave, silly. October 11th, 2024 at 9:17 a.m.
And what about this message in blue?
That's Mr. Hernandez to Amanda, states, put the hard hats on the porch, please. October 11th, 2024 at 9:17 a.m.
And what about this message in green?
That's Amanda to Mr. Hernandez. Okay, October 11th, 2024 at 9:17 a.m.
And the next message?
It's Amanda to Mr. Hernandez. Where are you parking the Jeep? That's October 11th, 2024, 9:17 a.m.
And what's the message in blue?
Mr. Hernandez to Amanda at the house, October 11th, 2024, 9:18 a.m.
And this message in green?
Amanda to Mr. Hernandez. Warren, That's October 11th, 2024, 9:18 a.m.
And what about the message in blue?
Mr. Hernandez to Amanda, at your mom's. You're going to have to come get us. October 11th, 2024, 9:18 a.m.
And the next message.
Amanda to Mr. Hernandez. Oh, okay. October 11th, 2024, 9:18 a.m.
And the top message.
Amanda to Mr. Hernandez. I was confused. October 11th, 2024, 9:18 a.m.
And the message in blue.
Mr. Hernandez to Amanda. Okay. October 11th, 2024, 9:19 a.m.
And the message in green.
Amanda to Mr. Hernandez. When do you think I'll have to do that? In like 2 hours. That's October 11th, 2024 at 9:19 a.m.
And this next message there.
That's from Amanda to Mr. Hernandez. Just bring the keys inside. I'm going to sleep. October 11th, 2024 at 9:59 a.m.
And this top message right here.
Mr. Hernandez to Amanda, you sleep. October 11th, 2024, 10:24 a.m.
And the next message on the page.
That's Amanda to Mr. Hernandez. I was. Why? October 11th, 2024, 10:25 a.m.
Wait a minute. This is like the weirdest thing. Y'all pause this for 1 second. Just Shamrock. I got a question. I do have to ask a question. You know, I love you dearly and I so appreciate everything, right? But let me ask you, how you the gifted 20 memberships? Shout out. That's the most that we had gifted in one time. So you the first person to do it. But how you not in green? I'm like, how she the gifted memberships that she not even in green. I'm like, well, maybe she didn't made a mistake. And it's just not my screen, right? I said, well, maybe it's just my screen. I'm like, she's not in green. Thank you, Maddie. I guess we gotta figure out how to hit her. Oh wow. I'm like, wait a minute, she not in green and she didn't gift it 20. Thank you so much, Maddie. Oh, Matt said go keep trying to send them so we can try to get you. Oh my. And it's so sad that we cannot even figure out how to like we can't just send them out to people. Yikes. You say you because Iris is the okay. I'll take that. I'm like, why is she not green? I just had to stop and say that because I see your message and I'm like, well, wait a minute, maybe it's my screen. Awesome. Thank you so much, Maddie. I appreciate it. Welcome to the new members. You know, we always welcome them. It was just funny to me. I'm like, yeah, you're not shooting in the right direction, Maddie. I don't know. Hey, Capri Law, how are you? Oh, Maddie is on a mission. He on a mission to seek and destroy. Your aim usually be good, Maddie. He putting in 20 now. Wait, can you turn it on or off? What do you I don't know, Just Shamrock. I don't even wear green on St. Patty's Day. It's just in my blood. She says she don't wear green. It's just in her blood. She ain't gotta be, she does not have to be green. How funny. Go on, Maddie. Look at Maddie. Maddie said he gonna make you green, even if you don't want to be green. I'm telling you, because Maddie's so handsome. He just told y'all, guess who's at home? Pants are in the washer. Oh, he's so handsome. Yeah, make sure. So Shamrock must not have give, receive, and enable. I don't know. You say your aim is true. Trust me. I'm gonna take your word for it. I'm gonna take your word for it, Maddie. I'm pretty sure it is. I'm sure you're a straight shooter. Yeah, I don't know how that goes. Like, and it's sad. I mean, I know why they don't do it, but I don't understand why we can't pick, who gets them. Right? What you mean membership options are not available to you, SD? Ooh, Baka says she do love a bow tie, Maddie. Oh, he's so handsome. Oh. Look, oh gosh, what are you doing? Y'all see Just Shamrock? Oh, Just Shamrock said, don't be playing with her. Maddie, you better come back. You better do better than that. They got therapists in here talking about holy balls. Oh my gosh, you are. Oh my goodness. Thank you so much, Just Shamrock. Oh, guys. She said she don't need to move over, little Maddie. You can't shoot right. Your shots don't work. No, none of that. Oh my goodness. Thank you. Oh gosh. Y'all know I'm a sucker. So she didn't get the tears the first time because I was trying to hold out because y'all know I gotta fight Barbara at the end of the day. But now I can't do it. So oh well, it's Friday. Y'all live with me. It's all right. Thank you so much, Just Shamrock. I really, really appreciate it. And to all the new members, welcome. If you receive that new membership from Just Shamrock, you make sure you come up in this goddamn chat and you say, thank you, Just Shamrock. That's what we gonna say. Wow. Thank you. He said, I was just trying to get you to be a member so you could join this members only chat. Look, I wasn't trying to fight with you out here in these streets. That's what he said. He wasn't trying to fight with you out in these streets, Just Shamrock. He just wanted to make sure that you could be a participant in everything that we doing. A therapist said you bet not. Oh wow. Oh gosh, thank you so much. Yes, welcome to all the new members. Woo woo. It's gonna be a party, y'all. Shammy out there swinging that big stick. Yeah, you better go sit down. Cause she done told you. Oh goodness. Oh we just Shamrock so handsome. They done took your whole little name. You bent yourself. She's okay. Back to the trial. Okay. I got it.
That's Amanda to Mr. Hernandez here,
Oh.
October 11th, 2024 at 12:08 p.m.
Okay, Detective. What's the date and time stamp of this bottom message right here?
That is October 11th, 2024 at 3:43 p.m.
And what was this a link to?
This, reading the link, it's from Amanda to Mr. Hernandez. It's from WXYZ, which would, I believe, be Channel 7. And it's a link to a headline that states suspects posing as workers, murder man, duct tape woman at home in Rochester Hills.
Can you read that top message?
Amanda to Mr. Hernandez, what do you want to do? October 11th, 2024 at 3:57 p.m.
And the next message?
That's Mr. Hernandez to Amanda, we need to leave. October 11th, 2024 at 3:57 p.m.
And can you read the next one, please?
Amanda to Mr. Hernandez, we need to get you out of here faster. October 11th, 2024 at 3:58 p.m.
And what's the following message?
That's the same date and time and states, we don't have the money to do it.
Can you read the top message?
So Amanda to Mr. Hernandez states sweating, October 11th, 2024 at 4:41 p.m.
And the next message?
Amanda to Mr. Hernandez, WYA, commonly known as where you at. That's October 11th, 2024 at 4:42 p.m.
And what's this message in blue?
It's Mr. Hernandez to Amanda, driving, October 11th, 2024 at 4:42 p.m.
And what about this message in green?
Amanda to Mr. Hernandez, coming here, October 11th, 2024 at 4:42 p.m.
And this message on top in blue?
That's Mr. Hernandez to Amanda, states, I'll talk to you when I get home. That's October 11th, 2024 at 4:43 p.m.
What about the message in green?
It's Amanda to Mr. Hernandez. Are we still leaving tomorrow or what? That's October 11th, 2024 at 4:43 p.m.
And this message following one?
That's Amanda to Mr. Hernandez. Call me FT audio. That's FaceTime audio. October 11th, 2024, 5:06 p.m.
And then your review of cell dry extraction reports, when it says FaceTime audio, what does that mean?
No, that's a text message. She's requesting. FT usually normally stands for FaceTime, as FaceTime audio to make the phone call.
Thank you. And then this message down here at the bottom.
Mrs. Amanda, or that's Amanda to Mr. Hernandez. Don't get the plate just in case. October 11th, 2024 at 5:14 p.m.
And then what about the top message?
Amanda to Mr. Hernandez. What if there are cameras you can't see? October 11th, 2024 at 5:14 p.m.
And what about the next one?
That's from Amanda to Mr. Hernandez. States, put gas in so it don't look like you drove far. That's October 11th, 2024 at 5:23 p.m.
And the message in blue?
Mr. Hernandez to Amanda, I am. October 11th, 2024, 5:34 p.m.
And the next one?
Amanda to Mr. Hernandez, I'm done. October 11th, 2024 at 5:46 p.m.
And the top one?
Amanda to Mr. Hernandez, I'm so sad, baby. I'm so sad. October 11th, 2024, that's 8:39 p.m.
And the next one?
That's Mr. Hernandez to Amanda. It's going to be okay. October 11th, 2024 at 8:40 p.m.
And then October 11, 2024, about 8:40 p.m. That was after the homicide at Newcastle.
Yes.
And this message in green.
Amanda to Mr. Hernandez, promise. That's October 11th, 2024 at 8:40 p.m.
And this message in blue.
Mr. Hernandez to Amanda, promise. October 11th, 2024 at 8:40 p.m.
Give me the top one for us, please.
Amanda to Mr. Hernandez, think it will blow over. That's October 11th, 2024 at 8:40 p.m.
What message in blue?
Mr. Hernandez to Amanda, yes. October 11th, 2024 at 8:40 p.m.
And can you read that message in green right here at the
That's Amanda to Mr. Hernandez, states, I don't think anybody will tell that it's you. That's October 11th, 2024 at 8:41 p.m.
in the message in blue?
Mr. Hernandez to Amanda, I pray not. October 11th, 2024 at 8:41 p.m.
And can you read the top one in green right here?
It's Amanda to Mr. Hernandez, states, me too. October 11th, 2024 at 8:42 p.m.
And the next one, please.
It's Amanda to Mr. Hernandez, I just got back here. It's October 11th, 2024 at 8:44 p.m.
And also, did you also examine other messages that belong to Mrs. Zuazo's phone as part of your cell phone extraction?
Yes, I did.
And there was other messages that was in his phone that was concerning the crime that you were investigating.
Yes.
Okay. At this time, people are going to move to admit and publish People's Exhibit number 24.
I have received exhibit number 24, no objection.
Objection, Your Honor. 24 is in.
And we're going to do it the same way. Not going to be as many, but we'll read some of those messages, okay? And this is a copy, fair to say, it's a copy of the cell-pride extraction form that you were probably given from Detective Boyce.
Yes.
Okay. And up here is Joshua Zuazo's email address.
I apologize. I believe this one I actually extracted myself.
actually extracted?
Yes.
And so up here on top is participants Joshua Zuazo and someone by the name of SD in that particular phone.
That is correct.
And then you, in the same process and procedure we're doing before, can you go ahead and read some of these messages?
Yep. So this one's from Mr. Zuazo to the contact of SD. It says, you got a second? I need to holler at you on some money shit. You really ain't got to do anything though. And that was on September 28th, 2024 at 3:37 p.m.
Okay, and this message in blue?
That's SD responding to Mr. Zuazo. What's good? Damn, you just blocked me and shit. That's September 28th, 2024 at 10:30 p.m.
And then what's the message on top?
That's from Mr. Zuazo to SD, says, I'm not a finisher yet, but by next year, I'll pick up 2 or 3 more different tools. That's September 30th, 2024, 3:14 p.m.
To SD.
To SD, I apologize.
Oh, no problem. And that next one, if you're in blue?
That's from SD to Mr. Zuazo, says, yeah, I used to do hard surface with DT. That's September 30th, 2024, 3:15 p.m.
And then this next message.
Immediately following, SD writes DTE. That's September 30th, 2024 at 3:15 p.m.
And then this message in blue on top.
That's from SD to Zuazo, says, I got all the stickers for you and the DTE helmet and a vest for you guys. That's October 1st, 2024 at 10:49 a.m.
And this message here in green.
That's from Mr. Zuazo to SD, states bet. That's October 1st, 2024, 10:49 a.m.
And then this message here in green. Can you read that for us?
That's from Mr. Zuazo to SD, states, everything go right, I'll give it to you. That's October 1st, 2024, 10:51 a.m.
And the message in blue.
SD responds with bat. That's October 1st, 2024 at 10:51 a.m.
And then this message between those parties that we're talking about. Can you tell us what this is?
It's a screenshot of DTE items. It appears to be vest, hard hats, signs. I do recall there being a photo in the phone that was stored in the phone in the Celebrate program that resembles this exact picture.
Okay, and
That's from SD to Mr. Zuazos, and that's on October 1st, 2024 at 2:12 p.m.
and then this message right here.
That's from SD to Mr. Zuazos. I got it all ready for you guys. That's October 1st, 2024 at 12:12 p.m.
And then this message on top.
That's from SD to Mr. Zuazos. Got lights for you guys too. That's October 1st, 2024 at 2:34 p.m.
And this message right here in green.
That's from Mr. Zuazos to SD. You can have both if shit goes as planned. That's October 1st, 2024 at 2:52 p.m.
And then the message in blue.
That's from SD to Mr. Zuazos. I hope it does. October 1st, 2024 at 2:56 p.m.
And this message here in green.
Mr. Zuazos to SD states it should. That's October 1st, 2024 at 2:57 p.m.
And while we're speaking of defendant Zuazo, while you're investigating this matter, were you able to determine what Mr. Zuazo's shoe size was?
Yes. During the investigation, we determined that a size 10.5 had been booked into property.
That belonged to
Mr. Zuazos.
I have no further questions.
Cross-exam, Zuazo.
Thank you very much. Detective, I know that you've heard me explain to every other witness about the questions I'm going to ask you this morning, but if I don't make myself clear, please tell me that and then I'll rephrase the question.
Yes, sir.
Okay? You mentioned early in your direct testimony this morning about Mr. Zuazo being taken into custody on October the 14th. Is that correct?
I believe that was the date.
Okay, and that would be like the Monday following the Friday where Mr. Murray's and Mrs. Murray's house was, where the incident occurred at their home.
Yes, I believe that was Monday.
And he was arrested, as you understand it, by a group of fugitive apprehension team members.
Yes, I believe so.
And that's a combination of Oakland County Sheriff's deputies and also associated with the United States Marshal Service. Is that correct?
I believe so, sir.
And were you present for that?
I was not, sir.
But you received a report that Mr. Zuazo was arrested on that date by that team, correct?
Yes, sir.
And the place where he was arrested was in Plymouth, Michigan. Is that correct?
I do not know the exact location of where the arrest was made. I believe it was Plymouth, but I'm not 100% sure on that.
The place, regardless of the address, was a job site where a house was being built. Is that
Yes,
correct?
I believe it was taken into custody there.
And there were a number of people that were working at that job site on that day, one of whom was Mr. Zuazo, correct?
Yes, sir.
And so then he was taken into custody. No one knows, I assume that the rest of those people went back to work, but they didn't go to jail or they weren't taken into custody, correct?
Correct.
And this happened in Michigan, while you don't know the address, somewhere in southeastern Michigan, correct?
Yes, I believe so.
And there wasn't any doubt about Mr. Zuazo being at work, correct?
I don't know the facts of the actual observation.
You're the officer in charge. You understand, you saw the
I understand he
video
was
of
taken
his
into
arrest,
custody at
right?
work. Yes.
And in the background of that arrest where it occurred on a front lawn, there was a house under construction, correct?
Yes.
And the people that were there with him, that were all told to get on the ground at the time of his arrest, were working at that place, correct?
I believe so.
Okay. And so when Mr. Zuazo was arrested, he didn't run away, correct?
I don't believe so.
And he was cooperative to the extent that he obeyed what the commands given to him were by the fugitive apprehension team members, correct?
Yes, I've received no information otherwise.
Okay, thank you. And as I said, or I asked before, that happened in Michigan, not in Louisiana, correct?
Yes, it was in the state of Michigan, sir.
And so now we've seen a number of text messages back and forth between Mr. Zuazo and a person named SD. Did you ever determine who SD was?
We still have been unable to determine. The phone number has come back to multiple different sources. It appears to possibly be some sort of pay-as-you-go phone, which doesn't always have a history associated with it.
That's a lot different than the situation with Amanda Diaz and the phone that she had and used with her husband during
Yes,
the weeks leading up to
Yes, sir.
October 11th, correct? And then would you agree that there are many more text messages that were exchanged between the husband and wife, Amanda Diaz, or the wife and husband, Amanda Diaz and Carlos Hernandez, than the ones that were exchanged between Mr. Zuazo and Mr. Hernandez?
Yes.
Thank you. I don't have any further questions.
Any redirect based on Zuazo's cross?
No, Your Honor.
No. Okay, all right, and so jury A, yes, okay. We are going to take a break, jury A. It's not quite lunchtime yet for you, but it will be shortly, all right? So just stay in your jury room.
All right, the jury, please.
I tell you, I just continue to try to look and see if I can find some information in regards to the actual court, but I can't find anything. And it's really like irritating too. Because I'm with you guys, everybody need to be charged. So it looked like they're sending the one jury out because, of course, our guy Bigums over here, he got more evidence against him than anybody else in this whole courtroom.
Referring to Zuazo, he's afraid of what you and your people can do to him and his family.
Officer in charge, you understand, you saw the
I understand he
video
was
of
taken
his
into
arrest,
custody at
right?
work. Yes.
And in
You're in charge. You've had an opportunity. Already, You also were able to watch previously and then yesterday in court the interview of Mr. Hernandez, correct?
Yes, ma'am.
Okay. And you heard when Detective Wiegman stated, referring to Zuazo, he's afraid of what you and your people can do to him and his family. Do you remember that statement?
Yes.
Okay. That is not accurate, correct?
I know I've had a chance to review the tape, and Mr. Zuazo states something along the lines of, I don't know what Carlos has going, but I made reference to protecting his family, but did not, that specific quote that you gave, no, that was not said in his interview.
Okay.
Or attempted interview.
And actually, Mr. Zuazo, was he given an opportunity to have a sit-down interview just like Mr. Hernandez was?
Yes, he was.
He decided not to give an interview, correct?
Correct. He exercised his Miranda rights.
Now, I want to draw some attention to the text messages, specifically between Mr. Zuazo and Mr. Hernandez. There was no text dealing with anything involving planning a homicide, correct?
I don't recall reading any text that plan a homicide, no.
No conversations about weapons?
No, ma'am.
You testified that some of the messages appeared that they had been deleted by the user in looking at those messages that were found on Mr. Zuazo's phone. Is that correct?
As I stated, Mr. McGarrell pointed out the user deleted. I don't exactly know how that actually works as far as the Cellbrite program. That's outside my realm.
Okay. And as you stated, a user may believe they're deleting something from their phone, but Cellbrite has a little bit of extra power.
From what I understand, there can be messages that are in the background that are not totally deleted from the phone, yes.
In talking about the messages between Carlos and his wife, fair to say that the texts are about a larceny or a theft that is about to occur, correct?
Would appear so.
There's text messages like, if you have to leave with nothing, that's okay.
Correct.
I hope we get enough money to buy a house.
Correct.
No messages about a weapon.
I do not recall any.
No messages about planning a homicide, correct?
I do not recall any.
I don't have anything further.
We need to wrap.
Nothing, Your Honor.
Okay, let's bring in our other jury.
Witness can step down, Judge.
No, because we'll wait till the jury comes in.
All right, for the jury, please.
Please be seated. Any further questions for the detective?
No, Your Honor.
All right, you may step down, detective.
Thank you, Your Honor.
People, next witness.
Your Honor, at this time, the people of the state of Michigan rest.
Okay, all right. So what I'm going to do now is, you guys are getting your steps in, okay, if nothing else, all right? We're gonna take a break, and it's not yet lunch, okay? So take a break, go back to your jury rooms.
All right, for the jury, please.
Let's be seated. Next word close. Any motions for directed verdict?
Your Honor, I have a motion to
Go ahead.
present on behalf of defendant Joshua Zuazo. Your Honor, Mr. Zuazo is charged with first-degree felony murder in count 1, and in count 2, unlawful imprisonment of Hussein Murray, and in count 3, unlawful imprisonment of Linda Murray. Your Honor, the first thing that I would like to address is the unlawful imprisonment of Linda Murray, because it's evident from the testimony that she gave that the person who bound her up and had her unlawfully imprisoned was the co-defendant, Mr. Hernandez. She never said anything about Mr. Zuazo apprehending her in any way. And furthermore, she testified that it was Mr. Hernandez who slapped her or smacked her or punched her when she didn't give the answers that he would have liked to have heard regarding where the money, the jewelry, and where the valuable property in the house was located. That seems to be a very clear case of unlawful imprisonment brought against Mr. Hernandez, but certainly not against Mr. Zuazo. And then, when we talk about the unlawful imprisonment of Mr. Murray, there's no evidence to say exactly who did all of that. But the person who was seen in the videos from the two different hardware stores, Home Depot and Lowe's, that's paying to buy these items that shows up on these receipts is evidently, there is clearly in evidence, Mr. Hernandez, who was getting money out of his pocket, and he's paying for all that. Who else is there? The second person has got either a bottle of Coke or a bottle of some sort of water, that it's Gatorade water, something like that. He's not a participant in making any purchase. So those items that were used on Mr. Murray as well as on Mrs. Murray were purchased by the co-defendant, Mr. Hernandez. And so I'm asking for a directed verdict as to both of those counts, and then going directly to the first primary count, first-degree felony murder. I submit that there hasn't been enough evidence presented that would make Mr. Zuazo even be present in the place, in spite of the fact that Ms. Murray did identify Mr. Zuazo as having been present that day, because we have two other witnesses who testified, the police officers who spoke with her soon after this event took place. That was Detective Hagelin on Friday, the 11th of October, and then Detective Wiegman, who testified yesterday about 3 at least interviews he had with her. She didn't give a specific identification, and she didn't give the specifics about this, even the person. The only characteristic she gave about the second participant in the robbery was a person of average build, and that was it. Not 6 foot tall, nothing specific like that, even though that's what she testified to. So that raises the issue of identification. I know I'm going to be receiving an instruction on identification for the jury, but I'm asking here in this motion for a directed verdict that that charge be dismissed, directed verdict of acquittal as well, because of the lack of identification evidence presented during the people's case in chief. I understand that the standard is that you have to view the evidence in the light most favorable to the prosecution. People versus Hampton and all of his progeny stand for that proposition, and I certainly am aware of it, and I'm submitting on behalf of Mr. Zuazo that people haven't met that burden, and it is for that reason I'm asking for him to receive a directed verdict of acquittal on all 3 counts. Thank you.
Okay. All right, thank you, Mr. McCarthy. Ms. Faulkner, are you joining in?
Your Honor, but only as to count 1. So I'm asking for a directed verdict only as to the felony murder count. Obviously, as Mr. McCarthy just stated, you're to view the evidence in the light most favorable to the prosecution. But when we look at the elements of first-degree felony murder, obviously the second prong there is the mindset that Mr. Hernandez had at the time. I do not believe that there was any testimony, and that none can be inferred from the testimony that was provided. So I do believe, even in viewing the light most favorable to the prosecution, that count 1 as to felony murder should be a directed verdict.
Okay, thank you. Response by the people?
Judge, everyone knows the standard. This court knows the standard. And at this point in time, I don't believe any of these motions should be granted. The case should go forward to the jury. These are jury issues at this point in time regarding Mr. McCarthy's issue regarding his client, whether or not he was involved with Mrs. Murray's captivity up in the first story. I think one, there's aiding and abetting, which would indicate that. Two, the defendant's DNA is on those duct tape rolls, as is the other defendants. Both duct tape that is down in the basement is found down there. And also, Mrs. Murray indicated that the defendant, Zuazo, wanted to put her in the closet before they left, along with the defendant. So I believe a lot of this is for closing argument. Obviously, they're both ready for closing argument, but to direct a verdict out, I don't believe it's appropriate this time.
Okay, thank you. The court does review motions for directed verdict to like most favorable to the non-moving parties, which is here is the prosecution. First, we'll start with Mr. Zuazo's motion for directed verdict pursuant to all three counts. Count 1, felony murder. Count 2, unlawful imprisonment. And count 3, unlawful imprisonment. The court finds that there is overwhelming evidence that Mr. Zuazo was a participant in count 1, felony murder, as well as the unlawful restraints of Mr. Murray and Miss Murray. Of course, the questions as to whether or not he is to be found guilty or not guilty comes down to a question of fact to this jury pool, who is court is confident will make appropriate decision regarding that. It is beyond me, Mr. Zuazo, that you sat through this trial for this past week and would believe that there would be any chance that this court would direct this verdict in your favor. Same with you, Mr. Hernandez. The evidence is overwhelming as to count 1 that you did partake in a felony murder, and the question is then going to be submitted to your fact finders, who the court is confident will make an appropriate decision as to their verdict. Both motions for directed are denied. Anything else?
Your Honor, at this time, I think that we could address the issue of the defense and what will be presented.
Sure.
I have conferred with Mr. Zuazo during the time that I represented him, and it is my understanding he intends to exercise his right to remain silent, and I would like to have him sworn so that he can inform the court about that.
Yeah, let's do that. Do you have any other witnesses?
The defense will not be presenting any witnesses.
Okay, Mr. Zuazo, stand up so I can get you sworn in, sir. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, thank you. Put your hand down. Tell us your name. You want to ask? Or
Yes.
Go ahead.
Mr. Zuazo, you and I have been working together on your defense since I was appointed to represent you in October of last year, correct?
Yes.
And we have been diligently preparing for this trial that has been conducted during this week, correct? And one of the things that we have discussed is whether you would testify or not testify, correct?
Yes.
You understand that that's a choice that you make. It is not a choice that I make, correct?
Yes.
And you understand that in the event that you were to testify, certain items of your personal background, which are not in evidence right now, would be brought up during cross-examination that would impeach you.
Yes.
And you have made a decision about whether it is, keeping that in mind, that you will testify before the jury assembled to determine the facts in your case, correct?
Yes.
And can you tell Judge Polis what your decision is?
No, Your Honor, I'm not going to testify.
Okay, all right, and you need to understand then you have an absolute right to remain silent, you have a constitutional right to remain silent, and you do also have a constitutional right to testify on your own behalf in your trial. Now that you've made the decision not to testify, be confident that this court will read an instruction to your jury that states the fact that you did not testify cannot be used against you in this trial, okay? And at any time you change your mind, I think we're gonna likely take a break between now and when we come back potentially for your closing. If there's any point in time where you change your mind, let your lawyer know, okay?
Yes.
Okay, all right. Ms. Lawson?
Yes.
All right, I'll get Mr. Hernandez sworn in. Go ahead and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. Put your hand down. Tell us your name.
Carlos Hernandez.
All right, your lawyer's going to ask you some questions.
Mr. Hernandez, I have been your attorney from the time that you were arraigned, correct?
Yes.
And we have discussed the fact of whether or not you would testify multiple times.
Yes.
And you understand if you wanted to testify, you do absolutely have that right.
Yes.
But also, if you did take the stand, you would be answering questions from me, but then the prosecution would have a chance to ask you questions. Do you
Yes.
understand that? And you understand also that you have a right to remain silent.
Yes.
And you understand that if you choose to remain silent, the judge would instruct the jury that they cannot use that silence against you.
Yes.
And you were present in voir dire when I actually asked the jurors if they would hold it against you. Do you remember that? Okay. Have you had enough time to make a decision whether or not you would like to testify?
Yes.
Has anyone promised you anything, forced you, or made you feel that you were unable to testify if you truly wanted to?
No.
Is the decision you're going to tell the court your own decision and your own free will?
Yes.
What is your decision? Would you like to testify or would you like to remain silent?
Remain silent.
Okay, and then same with you, Mr. Hernandez. You understand that by making a decision to not testify, you have a constitutional right to remain silent, but you also have a constitutional right to testify on your own behalf in your trial. The court would allow you to do that. Being that you told the court that it is your choice not to testify, be confident in the fact that I will read an instruction to your jury that the fact that you did not testify cannot be used against you. If you change your mind between now and the time before closings, let your lawyer know, and your lawyer will let the court know that you decided to change your mind, okay?
Okay.
All right, okay, thank you.
Your Honor, I do have one jury instruction issue
Judge,
because
just
we're going
one thing before we get to the jury instruction. I know you had asked Mr. McCarthy if he intended to present any other witnesses. I don't believe you asked that of Ms.
You're right,
Loft.
Ms. Loft, did you intend on presenting any witnesses?
I do not.
All right, what's the jury instruction, Mr.?
Your Honor, it's actually 16.4. It's the first degree felony murder. If you're looking at,
This is in Hernandez finals.
Yes.
Okay.
So when we're looking at the actual Michigan model criminal jury instructions that give some instructions as to the use of the particular instruction.
What number is this?
16.4 is labeled
16.04, count one, first degree felony murder, okay?
If you're looking at the Michigan model criminal jury instructions, at the bottom, it says paragraph 5 may be omitted if there is no evidence of justification for excuse, and the jury is not being instructed on manslaughter or any offense less than manslaughter. Here, there has been no evidence that there was some sort of self-defense claim. I'm not asking for those instructions. I don't think 5 is appropriate with the facts and the evidence that have been placed on the record. As to number 6, the model criminal jury instruction states use 6 or 7 where factually appropriate. 6 states to establish an attempt, the prosecutor must prove beyond a reasonable doubt, and then it goes to detail that. There has been no attempt established. The evidence clearly shows that individuals went into the home, items were removed. I don't think there's an attempt issue here, and I think that attempt instruction is going to confuse the jury, especially when they're going to be reading this in conjunction with an aiding and abetting instruction. So I am asking that 5 and 6 be struck.
Your Honor, I would join with Ms. Lofton's motion and also advise the court that as a member of the Model Criminal Jury Instructions Committee, this paragraph 5 has been the object of discussion. It is based upon a finding in a Court of Appeals case that is now being reviewed by the Supreme Court. But the Court of Appeals ruling was that it has no business in any of the homicide instructions because there's this not justified, excuse, or done in circumstances to reduce the lesser crime doesn't apply.
I feel like that does apply on the premeditation standard, but I don't see how element 5 applies to this particular fact pattern.
Judge, I don't have any objection if the defense wants 5 removed.
Yeah, because there's been no evidence presented that the killing is not justified, excused, or done under circumstances that reduce it to a lesser crime. There's no lesser crime. I'll strike 5. Okay, so 6. Do you join in that as well, Mr. McCarthy?
I do, because I don't believe the evidence is attempt, given the fact that stolen property was found in Mr. Hernandez's vehicle.
In order to qualify as an attempt, the action must go beyond mere preparation to the point where the crime would have been completed if it hadn't been interrupted by outside circumstances. There is no evidence that suggests that anything interrupted this crime.
Well, I would believe to argue that if what some of the things Mr. McCarthy has indicated to the court about identification, it's going to be that those things interrupted his client from appearing at the scene. So that part.
Wait, say that again?
I don't think Mr. McCarthy, from what we've talked about, is going to agree that his client was there for this. So something interrupted his client from showing up to the scene to participate in this. I also don't know if there's going to be an argument that, well, at some point, my defendant, whichever one we're talking about, decided to leave and not participate in it. So I think that should be left in there, quite frankly.
To leave during the larceny or to leave during the murder? Or what?
Well, it would be, since it's not a premeditated murder, there's not a preparation for the murder, but there is preparation for the larceny. And that preparation, as we've seen through the text messages, there's preparation for that larceny by him. And it's not that you can't prepare to do a larceny that then turns into a felony murder. So he's preparing for a larceny. So I think that instruction should stay in there.
Well,
Hang on one second, I'm just gonna read it to myself again. Okay, well, so then I do understand what the prosecutor's saying. I think that this is what I wanted answered by the defendants regarding the portion of it that says things like planning the crime or arranging how it will be committed are just preparation. So we just heard an hour and a half of testimony, of text messages that talk about potential preparation or what the jury could see as preparation. This specific instruction says that doesn't qualify as an attempt. So the fact that those messages are going on in and of themselves is not preparation of a larceny. For it to qualify as an attempt, there has to be an action that goes beyond this preparation to the point where the crime has been completed. So if you, Mr. McCarthy, get up and argue and say, and I don't know if you're going to, and I guess we can take it under advisement until that point, but if you get up and argue to the jury to say, yes, my client was in those messages, they got him there, however, he never showed up to the house that day, that would indicate that there was potentially an attempt or mere preparation, which would be your argument.
You are correct in the sense that this is mere preparation. All those things that happened before October the 11th are indeed preparation. Whoever's doing them, whatever that preparation was, is a question of fact for the jury to decide.
So you want this instruction?
No, I don't. I don't think that that should be in there because this isn't an attempt. This crime was completed by someone. My whole point here is that it isn't, and this is what the argument's going to be, it's not Mr. Zuazo. And I think that paragraph 6 should not be included as a part of the instruction, the same as I argued about paragraph 5 being out. And I think that that last half, and that was the thing that I was focused on, the things like planning a crime. One can plan something and not carry it out and not be a part of it, and that doesn't make them guilty of a crime, even if somebody else did it. If you're going to argue aiding and abetting, that's a different thing. And if you can establish that somehow or another the actual actor was being told to or put out there by another person who's the aider and abetter, that's a different circumstance. But that's not what we have here. Factually,
okay, so I'll
based
just
on
give
the
it a
record.
second. So I understand that point. The hypothetical that I think that then this could apply for is a situation of where somebody is attempting to go into the home, but then are stopped at the door, and their attempt is to do it, and then it results in a felony murder because that was the person's attempt to do it. But here we've seen evidence that the home was ransacked, that whoever was in that home, in fact, did commit a larceny.
And that's the point, because the instruction itself in paragraph 4 says the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. So if he's going to say his guy didn't show up there, and let's say they believed it, he could still be guilty of first-degree felony murder from all the stuff he did leading up to that, because he is helping. That's the preparation.
Aggravating and abetting.
And that's for the jury to decide by applying the facts to the law. But if you don't give the rest of the law, they won't have that ability to apply it. So that's a jury question of whether it is or isn't preparation, whether he is or isn't there. So he could still not be there, and yet be guilty of first-degree felony murder.
But I guess why are you believing that an attempt instruction applies at all? Because the next element here says the defendant must have been either committing or helping someone else commit the crime of larceny.
Yes.
So that could apply to both.
Regarding Mr. Zuazo, he is helping someone else commit the crime of larceny from everything we just saw in the text messages. So that,
7 is good.
well, I don't think we were even talking about 7.
But I'm saying
Yeah.
7 is what really describes, I think, the element for the instruction that the jury should focus on.
Judge,
Yeah.
let me say this,
Sure.
okay? My first concern in this case is protecting the record, okay? My theory is not going to be that he abandoned it. My theory is he was going to be there. If the court wants to strike 6, I'm fine with it. If I don't want that to be an issue on appeal, that we're worrying about something that I'm not even going to argue in closing that he abandoned it, I'm going to say he's there. That's not, so if you want to strike it for safety's sake, I'm fine.
But I think it's for like, I wouldn't be striking it for safety's sake. If I struck it, it would only be because I think it would be confusing to the jury when they're back there deliberating. But what's your position, Ms. Lofton?
Your Honor, in reading the actual model criminal jury instructions, it says use 6 or 7 where factually appropriate. So I think the instruction is
Let me
telling
see
us
that, bring that
we
up.
are not to use both. And I agree with the court. I think 7 is very appropriate.
It is in correlation with 8.1 and 4 and 5.
So the user note says paragraph 5 may be omitted if there's no evidence of justification or excuse, and we've done that. And then it states 4, third, that when the defendant did the act that caused the death of Hussein Murray, the defendant was committing or attempting to commit or helping someone else commit the crime of larceny. For the crime of larceny, the prosecutor must prove the following elements. The defendant took someone else's property. The property was taken without consent. There was some movement of the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises for that at the time.
Thank you so much, Capri. Yeah, thank you. We be trying over here. We trying in all ways we can, any shape, form, fashion. Right? I don't know what they talking about. They asking this judge for all this stuff in order to ask for acquittal. That is not going to happen. Please, can we move past this? I'm pretty sure y'all want to hear these arguments, so I'm gonna let us hear them. But not sure. But we'll hear.
And the property was taken, the defendant intended to permanently deprive the owner of the property. So that goes into explanation as to the removal of any properties, essentially the mindset versus what is actually taken out of the home in this factual scenario. and then it says you 6 or 7 were factually appropriate. The court is gonna find that 7 is more factually appropriate, and that the defendant must have either been committing or helping someone else commit the crime of larceny. To help means to perform acts or give encouragement before, during the commission of the crime that aids or assists in the commission. At the time of giving aid or encouragement, the defendant must have intended the commission of the larceny. And if this is on review to the higher courts, the court is referencing criminal jury instruction 16.4, first degree felony murder out of chapter 16 homicide out of the Michigan model criminal jury instructions. Okay, all right, anything else?
Only just to make sure I got it right, number 5 is being eliminated as well.
Yeah, 5
Thank
is
you.
struck and 6 is gonna be struck, so,
And 7 will be renumbered as 5.
and 7 will be renumbered as 5. So if we can do that to get the final instructions up to date for the jury,
Judge, let me ask you on that.
we'll do it.
Okay.
Yeah, at this point, we'll do it if there's any changes. What else?
I believe that's it.
Okay,
And that's it for me.
so now it's 12:20. Let me go back to our cheat sheet of whenever we were gonna do everything. So we need to bring back both jurors right now, because you guys are gonna rest, is that right?
Yes, Your
Counsel? Okay, and then we're gonna break for lunch for everybody, I think. at
Yes,
this
sir.
point. Okay, all right, let's do that. We're gonna try to resume back with closing arguments. Kind of like we had done with openings, those were done a separate times, that's what's gonna happen with closings, all right? So I can only anticipate how long I think it's going to be, so please bear with me. I will make sure to let staff let you know if it's gonna be longer than that. But because we all need to take a break right now, I am going to allow jury B, that's you guys, to go to lunch now for, it is 12:30, let's say, to be back in your jury room for an hour and a half. All right, so be back in your jury room at 2. Okay, so 2 p.m. for jury B. And then jury A, does 30 or 45 minutes sound okay for a break? Is that good? Long enough for a lunch? Okay. So then it's 12:30. Let's say be back in your jury room by 1:15. Okay? All right, thank you.
Okay, so they are going to lunch. Of course, we got our TiVo time, so we will go past that part, right? And I believe we're going into closing time.
Seated.
Please, the court. Counsel. Good afternoon. All the evidence, testimony, text messages are now before you. The case is going to soon be yours to decide when Judge Polis gives you the law to take back there. You'll have a written copy to read through. I was watching something just the other day, actually on YouTube. A guy was talking about perception versus perspective. And he was talking about how we go through life. Normally, we're looking at things as you go through it through your own perception. You know, you're seeing the events around you, the people around you, but there's also perspective, which is how are those folks looking at you? And that's stepping outside yourself and looking back. And I really thought about that coming into today's closing argument, because my perception doesn't matter. If it was my perception that mattered, I think I don't even need to make a closing argument. But that isn't what matters. What matters is your perception of the case, and that I don't know. So what we're going to talk about are things I think are important when you go forward, but it's impossible, and I'm not going to, and there's no way to do in 20, 30 minutes everything that we've discussed. It's impossible. We all have faith that you took notes. We all have faith that you paid attention. So go back and rely on that when you go forward. Now, we talked from the start about what this case is about and what this case isn't about. And from the start in jury selection, what we said is this is first-degree murder, but it's not first-degree premeditated murder. And we discussed that from the beginning. And Judge Polis will instruct you on what this is, which is first-degree felony murder. And that means, and the people have never said anything different, nor has law enforcement, that this was an intentional killing when they showed up on the doorstep on October 11th of 2024. And the judge will instruct you on the law, which is now before all the attorneys. And I'm not going to go through, there's a stack that Judge Polis will read to you, which there's no point going through it twice. But what you have to focus on regarding first-degree felony murder was that the defendants intended to commit a larceny, and that during that larceny, they caused the death of Mr. Murray by either intending to kill him or intending to do great bodily harm to him, or creating a high risk that death or bodily harm could occur. And then the judge is going to instruct you about aiding and abetting, which we also talked about. And it'll say anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. Now, I believe the facts have shown there were 3 people in that basement. Okay, and Mr. Murray is not able to talk about what happened in that basement. But I think the facts have shown throughout this, and I think the text messages tied everything in together even more, that from before, during, and after, these defendants had planned to commit a larceny at Mr. Murray's house. And each of them played different roles and different parts, but each of those parts were going together for that same mission, for lack of a better term. And you'll hear and you've heard that defendant Hernandez started a year before with his contact with Mr. Murray. He had personal contact at his pawn shop in Hamtramck a year before, October of 2023, where he was engaged in making pawns with Mr. Murray's shop. And then you heard, and you have the records, that in February of 2024, Mr. Hernandez appears again. And when he appears again, not only does he take some things out of pawn, but he asks to speak with Mr. Murray face to face. And Mr. Murray came over, shook his hand, looked him in the eye, and talked to the co-defendant Hernandez. And the other interesting part of that, because there are little bits that maybe don't seem that important, and maybe they're not, that's for you to decide. But what is Hernandez in there looking at? He's in there looking at Rolexes. What does Mr. Murray wear? He wears a Rolex. What does Mr. Murray have on him? He has jewelry. After that day, and as things went forward, you've seen the text messages, you've heard the connection between the 2 co-defendants, and it's a substantial connection. These are not Facebook friends who never hang out. These are not high school friends that only see each other at reunions once every 5 years. These 2 have had a close connection, and it continued throughout this time. And I think there's proof of that through witnesses and through the text messages. You heard from Ms. Diaz when she testified how the defendant, Zuazo, was going to be in the wedding in September of 2024. You heard from Ms. Diaz that she knows him by the nickname of Yogi. You heard from Ms. Diaz that she identifies the defendant that morning of October 11th when he's in the Lowe's with co-defendant Hernandez. You've heard as the testimony, the text, everything else is played out. You have lots of videos to show that they put their plan in place to physically start making it happen probably about 20 days before the murder. And you hear that through the text and through their actions. You start seeing the text that you now have today about we need a car between Hernandez and this defendant. And they go back and forth about getting a car. Why do they need a car? Well, they need a car because they want to get away with it, first of all. And they're going to do that by disguising the vehicle that they drive and then disguising themselves. They're going to disguise that vehicle after they steal it. And you've heard testimony from the victim of that theft about his car being left out and it gone, which coincides exactly with the text that you have now. You also saw texts that indicate that you need to disguise it with DTE materials. And you saw not just Hernandez walking in on video into that store to order up those signs for the sign of the car, but you saw this defendant text messaging his buddy, whether it's a male or female buddy, I don't know, but the buddy to get DTE products to disguise themselves. They go a step further, and that's to get rid of the plate, which was a very distinguished plate on the back of that truck, that Poco plate. And they got a DTE plate stolen from a DTE vehicle to make it even more unlikely that they're going to get caught if that vehicle is identified or if it shows up on a flock camera. Like everyone here now knows, is taking pictures of a lot of plates. Well, it would have come back with the DTE plate. And that disguise, as you heard, was so effective on October 11th that even Miss Niehaus, as she's walking her dog, and she said, my attention's drawn to that vehicle, first by the sound of it, but then it just seemed to be slow rolling through the neighborhood. And she said, I finally looked up and I saw it was marked as DTE. And I said, oh, it's DTE coming through to do something. And she was no longer concerned about the vehicle. Well, that's what these defendants intended. Now, you have the videos, you have the purchases at Home Depot, at Lowe's. They were getting the things that they were planning to use when they were going to get into Mr. and Mrs. Murray's house. They wanted duct tape, they wanted zip ties, they were disguising themselves as workers with different things that they purchased also at those stores. They were ready, but there was one thing that they could not buy at any hardware store for that day. And that was the will to do what was necessary. That will to go into that house and do what was necessary, you can't purchase that at a store. That came from in here. They were ready to go. And on that October 10th, when they drove there, it was this time of year, it is dark. You've got all the text before and after. And as they drive there, 40-minute, 45-minute drive, no one gets out of the vehicle. No one talks themselves out of doing what they're about to do. They're ready. They're planning, and as you saw through the text, Mr. Hernandez wants to buy a house. Mr. Zuazo is talking about needing a big score. And they had this impression that inside that house was going to be their big score. As they get to the house, and as you've heard, they approach the house, Mr. Hernandez in front, posing as DTE workers with Mr. Zhao right behind him. And that does not, is captured on Ring video. There's the knock on the door, which catches everybody's attention inside. Mrs. Murray said she gets it on her Ring video from her phone, and Sam is already downstairs and heads towards the door. She's upstairs, and she's paying attention. So Sam opens the door, defendant Hernandez with the co-defendant right behind them. They're trying to talk their way into the house. Mrs. Murray says, it's a little late to be doing a gas check. And then she says, Sam, do you have your gun on you? And she said, I said it loud so it could be heard. Mr. Murray doesn't want to let him in, isn't going to let him in, and doesn't let him in. Mr. Hernandez says, we'll be back tomorrow. So they leave that night, and then they have a 40-minute drive back to where they came from. Did anybody decide not to go forward with this the next day? No, there was a different type of discussion. And there's unanswered questions that we talked about in jury selection. Some of those unanswered questions don't matter, okay? It only matters if it goes to what we need to prove in these elements. One of the unanswered questions is, why didn't they force their way in? Okay, well, they didn't force their way in is what happened. But if you remember the positioning, Sam is downstairs. He is not a small man. He's 6 foot tall. He's 300 pounds. Hernandez is in the doorway, okay? And it's been told that he's armed. Could they have gotten to Sam before he pulled his gun? Could they gotten to Sam before he backed up and pulled his gun? I don't know. But what I do know is if they had come in that house, they could not have gotten to Mrs. Murray upstairs on that balcony before she called 911. There was no way they were getting to her before that call was placed. So they leave to regroup, and they regroup. They don't cancel it. They don't say there's Ring cameras, I'm not going to do it. They don't say the guy is 6 foot and 300 pounds. He may be a problem. No, instead they revise the plan. The plan doesn't get canceled. How do they revise the plan? Well, now they go first thing in the morning to Lowe's to get the 18-inch zip ties. So they're upping what they expect they're going to need to subdue Mr. Murray. The duct tape no longer is enough. They need zip ties. And those are the same length zip ties that the detectives described that is in the bloody scene in the basement. They have the drive back. No one gets out of the car. They both arrive. And as they arrive this time, when they're at the front door, which is captured on the Ring video, they're able to trick Mr. Murray into opening that door. Mr. Murray goes to the door, as you've heard. He lets them in, as you've heard, and Mrs. Murray is there watching this. She says it sounded like Mr. Hernandez was going to go outside, but he didn't. And you also heard that defendant Zuazo starts lingering around where the dryer is, which is a gas dryer. So they start going downstairs. And what's important to note is the little pieces of things, which you have, I'm sure you have. So Sam goes down the stairs first. Who's following Sam? This defendant, not Hernandez. The first one to go downstairs behind Sam is this defendant. The first defendant who's going to encounter Mr. Murray is this defendant. And Hernandez goes down behind him. The door is closed. And you know some of what happens next. We don't know all of what happens next because Mr. Murray isn't here to tell us. What you hear next is defendant Hernandez comes up and he immediately confronts Mrs. Murray, who's right there. She doesn't hear anything for that 10 or 15 minutes. No screams, no shouts, no commotion. But she sees Hernandez and he starts with, where's the safe? Where's the money? Where's the jewelry? And obviously that conversation triggers the realization that these are not DTE workers, that this is a problem. And she answers immediately, we don't have a safe. The money's in the purse. There's no real jewelry here. It's upstairs. And you hear at that point in time, defendant Zuazo comes upstairs. And when he comes upstairs, Sam isn't with him. And when Mrs. Murray sees Zuazo, she asks, where's my husband? And she's asking, where's my husband? And he comes up and hears that. Hernandez doesn't say anything in response to that. Zuazo does. And what he chooses to say is he's sleeping. And at that point, she sees the blood on this defendant's chest, and she starts screaming. Hernandez immediately punches her on the left side of the face, as you've seen the photos and as you've heard in testimony. And what else does Mrs. Murray say that is important? And as you look back through everything, all that we ever want is for you to use your common sense about what makes sense, what doesn't make sense. And what makes sense is exactly what she says. She says she sees his whole face because the mask is no longer in position. And what makes sense about that, because he's tried to disguise his face with the mask, both on the 10th and on the 11th. But why it's not in place anymore is because he had just been in a struggle with Mr. Murray down in the basement. And that mask had been moved and dislodged during that life and death struggle. And that life and death struggle was just Mr. Murray's life and death. These defendants were never concerned about their life or death. And if you heard, the only blood, there's DNA from the defendants. There's never any blood from the defendants. The only blood that you see, and there's a lot, is from Mr. Murray. Now, she sees his face, she describes him to the police officer, she describes the facial hair, and you heard the officer yesterday testify when he was arrested, he had facial hair. And then you've seen the Lowe's video from that morning where the defendant is there with Mr. Hernandez with facial hair, with the bucket hat that's later found. So does that end it? Does the defendant head for the door? Does he say, I'm getting out of here? No. Where does he head? He heads upstairs to continue the mission, which is to find the jewels or this treasure that doesn't exist. So he goes upstairs, and you heard that when he goes upstairs, those rooms are ransacked. You saw those rooms are ransacked. The costume jewelry is every place. And you also heard Mrs. Murray testify that Hernandez never went upstairs. Only this defendant went upstairs. And what else is upstairs? The victim's blood on that swipe on the wall. Because there's so much blood that was downstairs, the defendant got the blood on him and left it upstairs. As that's going on, Mr. Hernandez is still looking for items, trying to get into the purse, trying to take the car keys, taking the cell phone, taking all these things. And the gun is missing. Gun's never been found. Last time it was seen, it was going downstairs with Mr. Murray. That gun is missing. Mrs. Murray tells you that she's bound up by the duct tape. You saw how Sam is bound up in the basement. He's not just bound up with duct tape, he's bound up with the zip ties that they had just purchased. And then you hear this defendant returns from upstairs, wanting to go. We need to go. But what does he want to do? This defendant. He wants to put Mrs. Murray in the closet. He wants to put her in the closet before they go. And he starts trying to do it with Hernandez, but she's duct taped in a position that she can't be moved into the closet. So as much as they tried to even do more, they weren't able to. So they depart and flee. It's not over because they got to try to get away with the little that actual value that they took. The only thing of value that they took that day was Mr. Murray's life. That's the only thing of value that was taken. The rest was junk. What do they got to do? They got to go get that truck down in Detroit. And you saw the text messages where it sounds like it's pre-planned. You hear that they set that truck on fire to burn its contents, burn any DNA that's inside the truck, and then it's time to get out of there. Hernandez gets home. You've heard the testimony that he quickly packs up that Jeep, packs up his wife, packs up her child, and they start headed down south. Now, when they get down south, they don't have much of a drive before law enforcement is quickly on them. Law enforcement finds a lot of objects of value that are later processed. You've heard about all those objects, which include the 13 size shoe, which is Mr. Hernandez. And in fact, the video, you can clearly see he's wearing those Nikes in one of those videos. You also have the brown boots that are size 11 that are not able to fit Mr. Hernandez's foot. And you also heard today that the defendant's shoe size is 10 and a half. And I don't know about anybody else who buys shoes, but my shoe size range it's a large range between what brand you buy. 10 and a half, 11, 10, they all can fit the same foot, as everyone knows out of their own common sense. So they find the bucket hat that belongs and is seen on the defendant. You also find the jewelry items that were taken by the defendant. All of those things plus more are found in that vehicle. Now, at that point in time, the attention of the sheriff's office has quickly been focused on Mr. Hernandez and this defendant also. You heard from Mr. Broad, who calls into the sheriff's office and says, I know that guy. He testified yesterday. I know that guy. I worked with that guy. He identifies him from the video. He identifies the clothing from the video, and he identifies those boots being consistent with the type of boots that are used at their scene. So then you hear more gruesome details today from the medical examiner about the manner that Mr. Murray was killed. Those photos show a lot of light about what happened in that basement. It was a brutal beating, a multiple hit beating, a beating that could certainly have occurred with two people, regardless of their size. But when we talked about the Rolex, it's important when I think about things about how did it physically transpire. He has two strikes to the back of his head from a blunt object, consistent with a gun, consistent with a lot of other objects that could cause that type of injury. Okay, so Sam goes down. You know, they ask for the safe, maybe. He's not giving an answer, maybe. He says, I don't have anything, maybe. But you know that conversation occurs. It occurs upstairs, and they don't like that answer either. So Sam is struck and he's bleeding, but he's not quitting. You heard Mrs. Murray talk about he's a strong man. You've heard he's a big man, and he's not unconscious, because if he's unconscious, how could I say that? I wasn't there. Well, because it doesn't make sense with the rest of the facts in the case. If he's unconscious, you don't have to bind him up like that. You don't have to duct tape him. You don't have to duct tape his mouth. You don't have to zip tie him. This is a struggle at a minimum with Mr. Murray and the two defendants. And what else do you hear? That as much as Mr. Hernandez loves Rolexes, as much as the only thing of financial value in that whole scene that day was probably that Rolex, what happens during this struggle? The struggle occurs to the point where he's duct taped and zip tied where you can't even get to the Rolex. If he was unconscious, if he was the first thing that comes off is the Rolex. Maybe they try to get the ring off, but the thing of value is that Rolex. Can't even get to it, but they don't care because they're in a struggle with him. Now, that beating had many injuries to Mr. Murray that you've heard about. And we talked to the medical examiner about the compression to the throat and about if someone's struggling to break that compression, whether it's a knee, a hand, a foot, you know, it would reset your clock. You know, if someone's trying to choke you, you knock it away, it resets the clock, keep doing it. So I believe it's taking two people to try to restrain Mr. Murray. And that fact is borne out by the fact that you have blood on both defendants. There's no version where any defendant left that basement before that violence occurred. Impossible, because you're not getting blood on your boots, you're not getting blood on your Nikes, you're not getting blood on your shirt. Both shirts. because the t-shirt Mr. Hernandez is tested also has the DNA on the blood. So that battle is going on down there. And, you know, I try to think about it like just normal life, okay? I have a brother 4 years younger, okay? So growing up as kids, when we would roughhouse, wrestle, things like that, there was a point in time where I could get both of his wrists in one hand. And I could put him down with one hand and hold him in place. And then I had one hand free. That stopped when we were about 12 years old. I could no longer control him with one hand. There was no way one person was controlling Mr. Murray all by themselves to both tie him up, keep him in a position, do all that. That doesn't seem to me to be reasonable. I think Mr. McCarthy is going to say a few things at this point. Give him your direct, full attention like you have throughout this trial, and then I'll have a few minutes afterwards to address what he says.
Thank you. Ms. McCarthy.
Good afternoon. I want to thank you, first of all, for paying attention during the course of this trial. I talked about that in my opening statement. I think I may have touched on it a little bit while we were conducting the jury selection on Monday, but I did for sure talk about it in opening statement about how important it is to pay attention so that the 12 of you that are ultimately chosen to go back into the jury room and deliberate will have all the information you need in order to actively participate in those discussions. And I'm convinced that all 13 of you here present today, this afternoon, have fulfilled the solemn obligation of your oath. And on behalf of Joshua Zuazo, I thank you for having done so. And now it is, in a short time, going to be your opportunity as well as your obligation to do the one thing that brings us all together here, to discuss the one thing that brought us all together here this entire week. And that is to determine what the facts are. As I said in my opening, I'll repeat again, that a trial is a search for the truth. And you all are the truth finders. You are the people who are going to make a determination based upon the evidence presented during this trial of what that truth actually is. And then ultimately the practical reality of those decisions that you make in coming together and determining the truth is going to be whether you find that there's been evidence presented to the high standard of proof beyond a reasonable doubt to convince you that Mr. Zuazo is guilty of any one of these three crimes with which he is charged and for which he has undergone a trial before yourselves. First degree felony murder, unlawful imprisonment of Hussein Murray, and unlawful imprisonment of Linda Murray. One of the things that impressed me about the evidence that we have heard, and one of the things that I told you in the very beginning of the trial, is that this is about identification. And I understand Mr. Petrofess's argument, and he is attempting to convince you beyond a reasonable doubt that that second person who's there with Carlos Hernandez in the Murray home on the 10th day of October in the evening, and on the following morning, the 11th of October of last year, is Mr. Zuazo. But there's quite a difference between what you're able to perceive in all of the videos that have been shown to you, which, are exhibits, and you are all welcome, as Judge Polis will tell you, any exhibits that you want to see, you're going to be able to see again and go through them. And I encourage you to do that very thing, especially from that Friday when it's daylight and you can see. And take a good look at who that second person is. And ask yourself, is that really proof beyond a reasonable doubt that it's Joshua Zuazo, or is it somebody else? Because when it comes to identification, besides what you can see just in little clips from those videos, comes from Mrs. Murray and Kelly Broad. He testified yesterday. believe it was yesterday, it might have been Wednesday, but whichever day it was, he testified during the trial, and he is the person who used to be Mr. Zuazo's supervisor, 2 levels up from him, but some sort of a boss at the St. Mary Cement Company. And I don't know about you, but I had a little difficulty following what he was saying. I know he was here for a reason. First of all, he was subpoenaed, so he's obligated to be here. But he was here to make sure that who he says had threatened him when he fired him got convicted in this crime. He says that he knows it's Mr. Zuazo because in the video, he is wearing Wolverine steel-toed boots given to him by St. Mary Cement Company. And he's wearing safety glasses, prescription, he says, given to Mr. Zuazo by St. Mary Cement Company. So the thing that I ask you to do is scrutinize what he had to say. And the reason I say that is because in the instruction that the judge is going to give to you a second time, she's already given this to you once before the evidence presentation began, is about witnesses and sizing up the witnesses and making a determination about who do you believe. And one of those things that she's going to repeat is words to this effect about, does the witness try to actually answer the questions, or does the witness argue with the lawyer? And I would add this, does the witness ask the question presented? Now, I've been doing this job of representing people in trial and conducting litigation in civil matters as well as criminal matters for 45 years. And so I consider myself pretty capable of keeping people on point and getting them to answer their question that I put before him. Ask yourself in your memory how many times I had to repeat a question and ask him to answer the question that I put to him. Was he honestly trying to answer the lawyer's questions, or was he arguing with the lawyer? And this is a huge piece of evidence that is presented specifically to fill in some gaps about who that second person is and make it be Joshua Zuazo. I submit to you that Kelly Broad was not honestly trying to answer the questions. He was here with an agenda. He claims that Mr. Zuazo threatened his life, but he never reported that to the police. And he says that he can tell that these are Wolverine boots. The fact is, when I asked him the question, I said, well, all you can see is down at the bottom. The person who's wearing those shoes is wearing long pants. How can you tell all these things? Well, he just knows that that's true. Well, if that's so true, and the people's theory about Mr. Zuazo's presence at that place, the home of the Murrays, then how come there aren't some brown Wolverine steel-toed boots in Mr. Zuazo's house when it is subjected to a thorough search? Why aren't those steel-toed Wolverine boots that Mr. Broad is so certain were present in that video in the Jeep that is racing from Michigan to Texas and is stopped in Louisiana? Those are Timberline boots. And there's no evidence that those are Mr. Zuazo's boots. There's no DNA in those boots that says it is Joshua Zuazo's DNA. There is DNA that says that the blood on top of one of those 2 boots is Mr. Murray's. No question about that. Who is to say, what evidence is there that is reliable that it's Joshua Zuazo whose feet were in that boot? Where is this shirt that Mr. Broad claims he recognizes as a St. Mary Cement shirt or covering, whatever it was, this yellow looking thing that you can see in the video? How do you know that that's from St. Mary? When I told him that there was this in the video that I watched of him, on his shirt, he had a name tag, or the company name is what he said. I couldn't see it very clearly in the video I watched. But he explained, yeah, he says that's St. Mary Cement Company says that on this green patch. And then he adds in, of course, those can be easily removed. Okay, well, there wasn't one of those on that shirt. And he claims there's this thing on the shirt, though, that says fire repellent. I think was the two words, FP or FR. And so there'd be some kind of safety shirt that the St. Mary people have. He claims he can see that in that video. I encourage you to take a good look at that and see whether that's what you see. Or is what you see a name tag holder, a clip of some sort, something like all of you have for your jury badges, up there on that shirt that this second person was wearing, and not some initials from the St. Mary Cement Company, but just the clip to hold on to the fake DTE Energy tag. Question of fact for you to decide. Then we have the fact that the other person making an identification of Mr. Zuazo is Mrs. Murray. She's a compelling witness. And who among us would ever want to be in her shoes? And this was without question, and she honestly answered this for me when I cross-examined her a couple of days ago. The terrible, traumatic situation, an experience that she's never had before, of course, and is living with to this day, and cannot get it out of her mind, and thinks about it all the time, and certainly has it on the forefront of her mind because she had to come here and give this testimony. And she's here present and has been throughout the time that has passed since the time she gave her testimony. And so one of the other instructions you're going to get is that you cannot let sympathy or bias or any human emotion enter into your decision making. And I ask you to think about the two witnesses from the Holden County Sheriff's Department who testified yesterday, Deputy Hagelin and Deputy Wigman, about the description of the second individual that Mrs. Murray gave when they conducted interviews with her. Deputy Hagelin was not the first person who saw her. That was Deputy Copeland, who was the first man on the scene. And his interaction with her was rather brief, and he got her out of harm's way, or at least where he hoped it was going to be out of harm's way, so that he could summon more deputies, and he didn't have much interaction with her. Deputy Hagelin took her and put her into a vehicle, a police vehicle, for her own safety and to give her an opportunity to be sitting down and out of all of the activity that was going on in her home, and talk to her. And what she told him was that it was a person of average size, black male, but a person of average size. Didn't give any specifics. That was the same thing that she said to Detective Wigman, who saw her more often. He saw her in the hospital emergency room on the 11th and then of October. And then he said two or three or four other meetings after she was discharged from the hospital that day, in the following days. And those meetings were conducted in the home of her son. But never once did she give a description to say that Zuazo, or the second person rather, who she has now identified as Mr. Zuazo, was 6 foot tall. It was always a black male of average size. Now, she was specific in her description to Detective Wigman about who is, we know, Mr. Hernandez. Very tall and fat, very fat. One of the pieces of evidence that's been admitted during the course of this trial is that when Mr. Hernandez was racing away from Michigan to Texas, where he thought he could hide out until he was stopped by the Cato Parish Sheriff's Department in Louisiana, Shreveport, he got taken into custody And as is the custom or the protocol for putting a person into custody and incarcerating them, they take some statistics or, information regarding that individual. And they have him booked in at 6'6".
Hey guys, I just wanted to kind of like break in. I just wanted to let y'all know at the 4 minutes of deliberations, they have came back with a verdict. I'm not sure if we want to finish watching. Therapist has informed me after 4 minutes of deliberations about maybe about 40 minutes ago, they came back with a verdict after being back there for 4 minutes. So they kind of like went back there and they came back with a verdict. So I wanted to see, do y'all want me to show the verdict, or do y'all want to finish listening? It was like they was back there for like 4 minutes. They're like, what the hell? That's 2 minutes longer than it takes Zach. Yeah. It was like 4 minutes. I like the 4-minute thing. Oh, how funny. Let me get it up for us. I'm trying to watch it on channel 2, but they giving me all these doggone commercials. So give me 1 second. DTE. Wait a minute. Let me see. I don't know. For some reason, wait a minute. Let me see if I can find it. Okay, so that's the closing arguments. I can't imagine. They had to show it. Wait a minute. I can't even. It's not like it's not like regular. I don't know. I gotta find it. No, I gotta find it. I don't know why I can't find it. Yeah, I don't actually see like the stream of it, which is weird. I mean, I see the news article because I see it, but I don't see the. Let me see. Yeah, that is like so weird. I don't know. Maybe they ain't streamed it yet. I mean, like put it online. Me? Are you talking about me, therapist? Yeah, because this cannot, I don't, oh gosh. That's the one thing about looking at these local news stations is, Court TV would have had the countdown clock and all types of stuff. Mm. Okay. Okay. One second. I think I got it. Okay. Okay, we have a verdict. Let's see what our verdict is.
Ladies and gentlemen of the jury, please be seated. All right, so we are in receipt of your note that you have reached a verdict. Have you chosen a foreperson?
Yes.
All right, Mr. Foreperson, did you bring in that verdict with you? Okay, if I can just take a look at it and I just want to review it to make sure that it is signed and dated, and then I'm going to give it back to you and you can let us know what your verdict is. Okay, all right, I'm going to send this back to you. Just read as to each count what you found, please.
Count 1, first-degree felony murder. Guilty as charged of first-degree felony murder. Count 2, unlawful imprisonment. Guilty as charged. Count 3, unlawful imprisonment. Guilty as charged.
All right, thank you, Mr. Foreperson. We'll collect that verdict form from you, and you could be seated. Would anyone like the jurors polled?
Your Honor, I would make that request.
Okay, all right, juror in seat 1, sir, is that and was that your verdict?
Yes.
Juror in seat 2, is that and was that your verdict?
Yes.
Juror in seat 3, is that and was that your verdict?
Yes.
Juror in seat 4, is that and was that your verdict?
Yes.
Juror in seat 5, is that and was that your verdict?
Yes.
Juror in seat 6, is that and was that your verdict?
Yes.
Juror in seat 7, is that and was that your verdict?
Yes.
Juror in seat 8, is that and was that your verdict?
Yes.
Juror in seat 10, is that and was that your verdict?
Yes.
Juror in seat 11, is that and was that your verdict?
Yes.
Juror in seat 12, is that and was that your verdict?
Yes.
And juror in seat 13, is that and was that your verdict?
Yes.
All right, ladies and gentlemen, on behalf of myself, my staff, and the attorneys, we sincerely appreciate the time and service that you have put in this week. I know it's been a long day and a long week. If you can wait back in that jury room for me, I would like to come back and just say hello and chat with you. I'm not going to be able to get right back there, though. So if you have to leave, I do understand. But if you can wait, that would be great. I'd like to say hello. Thank you.
All rise for the jury.
All right, and bond is already denied here. Is that right?
Yes, sir.
All right, so bond remains denied, and we will come back here for sentencing on.
December 9th at 1 o'clock.
All right, December 9 at 1 o'clock. I'll see
Judge,
everyone.
the only thing, and I know Mr. McCarthy is aware, just at the time of sentencing, we need to address the habitual offender notice too for the record.
Okay, we'll do it then.
Very well.
We're all set. No, it's fine.
After an accident, the insurance company will do everything they can to deny your claim because they don't.
We gotta figure out a way to get some commercials up in here.
I'm trying to figure out, how did the juries come back at the same time?
Oh, okay, I'm gonna send this back to you, and if you could just read what your verdicts are as to each count.
Should you stand?
Sure.
For count one, first degree felony murder, the jury finds defendant Hernandez guilty as charged of first degree felony murder. Count two, unlawful imprisonment, the jury finds defendant Hernandez guilty as charged of unlawful imprisonment. Count three, unlawful imprisonment, the jury finds defendant Hernandez guilty as charged with unlawful imprisonment.
Okay, all right, thank you. We're gonna get that verdict form back from you. Would anyone like the jurors polled?
Yes.
All right, juror in seat one, is that and was that your verdict? Yes, I have to hear, we're recording, yes? Yes. Juror in seat two, is that and was that your verdict?
Yes.
Juror in seat three, is that and was that your verdict?
Yes.
Juror in seat four, is that and was that your verdict?
Yes.
Juror in seat six, is that and was that your verdict? Juror in seat seven, is that and was that your verdict? Juror in seat nine, is that and was that your verdict?
Yes.
Juror in seat 10, is that and was that your verdict?
Yes.
Juror in seat 11, is that and was that your verdict? Juror in seat 12, is that and was that your verdict?
Yes.
Juror in seat 13, is that and was that your verdict?
Yes.
Juror in seat 14, is that and was that your verdict?
Yes.
All right, ladies and gentlemen, on behalf of myself, my staff, and the attorneys, we sincerely thank you for your time and service. I know today's been a long day and it's been a long week, so we really thank you for your time and your commitment here. I always like to come back and say hello to my jurors. I know it's late in the day, so if you can't wait for me, that's okay, I understand. But if you can, I'd like to come back to say hello. Thank you.
All right, jury.
Okay, is bond denied here?
Yes.
All right, bond will continue to be denied and we'll come back here for sentencing on
December 9th, 1 o'clock.
December. Yes, does that work? December, yeah, go ahead.
My client has asked for a different sentencing date as a co-defendant when I told him that I would ask for.
December 9 at 1 o'clock.
Thank you.
All right, the motion is denied. Anything else for the record at this
Judge,
time?
Again, there's an habitual that needs to be addressed at sentence.
Okay, we will do that then. Ms. Lofton, anything else? Okay, all right.
All rise.
Two chains. Okay. So we got two of them that they done bit the dust. Another one bites the dust. You say 6 chains. 2 chains. Shame on them. Guilty, 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 guilty. So I guess we have to come back for sentencing for these cases. I guess we have to put that on our calendar of things to do in life. Listen to their sentencing. 2 chains. 2x4 chains. Yeah, it's probably 2x4 chains. Shame on them. Shame, shame, shame. Well, I guess we don't have to finish those closing statements because 2 of them that bit the dust. Got them all together. I think to remind you, 2 chains. I'm going to be like, sweet peas. Chain, chain, chain. Okay, so check it, y'all. I do need y'all. I gotta show y'all what our therapist made for us today, because I think it's freaking hilarious. And y'all probably be sitting back here like, why is she laughing so much? Y'all know I am hilarious. If you send me something funny, boy, oh boy, I'm probably gonna be tickled to death. So let me show y'all, because y'all, when we get off, I need y'all to go look at it. Because I think it's awesome. And shout out to therapists. I thank you so much for doing this. But yeah, it is just too funny to me. So I'm going to show y'all because it's funny, funny, funny to me. So I don't know if it's funny to you guys, but it's funny to me. Let me see. Let me show y'all. Let me show y'all the shout out to therapist for creating this for us. She's so awesome. She's so awesome. Like anything we need, she gonna get us all the way together. So here we go, guys. Let me share it. Did I share it? Am I sharing it? No, I'm not sharing it. Let me share it. Let me make sure I share it. Share. Oh, wait a minute. I ain't got the music on. Oh, wait a minute. Okay, let me play it again. That's okay. I can watch it a million and one times. So we good there. Wait a minute. That is too left out is on the page. We need an emoji of a cousin face. So shout out to the therapist that we know. And if that's your cousin, please report to the bench. Please check in with Take It to Trial, because I want to know why we're not telling her that she can't come out the house like that. And if you her best friend, please let me know. How do you let your friend go out the house like that? That's not what friends are for. They're for good times and bad times. Like, no. Yikes. That is too funny to me. The therapist. The therapist, you see this right here? Let me show you this right here. This may be what we got going on. I just want you to see it. This black screen, that may be half our problem, but we'll talk about it. That is too funny. So if y'all want to see something funny, y'all make sure y'all definitely go check it out. Barbara, you gonna be okay tonight? You not gonna take my head off tonight, are you? Let me know. You're not gonna take my head off tonight. Let's talk. Let me talk to you before I go in here and get myself together for tonight. He said, you said, oh, wait, Barbara. I don't want you to beat me up. Anything. Whoa. Hey, I have a code word. Nah, oh gosh. I need you to get back over there in the chat that made you mad and get back over there and get it off on them. We're a good Christian chat. That's right there. Just let her know. Oh, wait. I'm about to send her back out in these YouTube streets. She done came back all damaged. We don't do that over here, Barbara. We don't be damaging our people over here. And I told her to stay home, but no. She had to go out in these streets. You say your secret life just saying right. Yeah. Well, you definitely don't want to be on camera talk about who it is and he got it all falling out. Like she was doing the most out here in these streets. But yeah, Barbara, you better stay at home. She was representing somebody. No. Barbara, you know, all day she been coming in the chat. I gotta go here. I gotta go there. I see y'all later. Now she came back pissed. Now I didn't cut the street lights on way earlier. Oh, you can always be over here, boo. Oh, we ain't like that. I want to make sure that you'll never get fired up. You could always be over here, boo. You say you very. That's okay. I'll put these street lights on for you. When you out here in these YouTube streets, I'm gonna put the street lights on for you, Barbara, so you can come on home. Because I told you this is where home is where the heart is. and I be wanting you to come home. So sometimes I gotta put the street lights on for you so you can come home. You remember when your mom used to be like, when the street lights come on, you need to come home? That's what I be having to do. I gotta put the street lights on and get you to come home because I need you to come home. I need you be out here playing in these YouTube streets. That's okay. That is A-okay. So tonight we are going to discuss the sentencing verdict for Diddy. So if anybody has anything that they would like to add or talk about or express, we gonna open up a panel. It will be a panel discussion. Please BYOB, bring your own bottle, bring your own drink, bring your own pop, bring your own food, bring your own everything. Right? So I want everybody to make sure that they bring everything that they need to bring to the party. The party starts about 7 o'clock, right? 7 o'clock Mountain Standard Time. Barbara, that still works for you? And then we got 10 o'clock. Safe word is turtles. Y'all got it? We'll put it in the chat. Your safe word is going to be turtles. So everybody, so if anybody gets up here and you said you was always told if you wasn't about to here to come home. I'm telling them. Look at her going back out in them YouTube streets. What I tell y'all, she just keep going back. Barbara said she gotta go cuss out somebody else, another person. She'll be back at 7. Go get all your rocks off, Barb. Get it off. Look at her going back out here in these YouTube streets. She said she getting back out here. She'll see us later. She going to get all her rocks off before 7 o'clock. Yeah, so we'll have our safe word. I don't know, Leah. She going to one of these channels. She be out here on these YouTube streets. She be on these YouTube streets and she be out here. At least today, she has been out here on these YouTube streets and she has been getting it in. And they better leave her alone. Oh, no. Oh, hopefully not. Okay, Barbara, we're going to need you to calm down because I don't want you going there. Yes, ma'am, Just Shamrock. If you want to come back, if you up, I don't know what time zone you in, but you definitely come in and hang out with us. It's open to everybody. It's not it's open to everybody. So you say, see you next week. What time? Okay. Now I'll see you probably out here in these YouTube streets. Because I know you be on the videos and you be out there and you be commenting. So I'll see you on a video feed. Thank you so much again, Just Shamrock. Thank you. I truly appreciate it. And yes, if I don't see you until next week, I will see you next week. We will be here. All right. Well, Guys, I'm gonna let everybody go because remember I'll be get back on here in a couple hours so we can do our Take It to Trial After Dark. Don't forget to bring all your stuff. It's laid back, cool. We just kicking it, enjoying each other, discussing anything in regards to the trials. I mean, I named it the Diddy thing, but we can discuss any of the trials or anything that we covering or anything upcoming, right? And we'll kind of go from there. And just remember, you're in the right place, right? Where there's no filters, no fluff, right? Just facts. So you can be the judge. All right, guys, I will see you in a couple hours. Everybody be on your best behavior. Don't do nothing that I wouldn't do. And I'll see you at around 7. And we're going to kick it. All right.